Sarah, we live.
All right, the meeting of the California Law Revision Commission will come to order. It appears we have a quorum, so can we call the roll to establish a quorum?
Yes, I will. Thank you. So, Commissioner B,
Present.
Present.
Commissioner Kubas should be joining shortly. We're awaiting her. Commissioner Hebner is not available today. Commissioner Jenkins,
Here.
Commissioner Pacheco or Assemblymember Pacheco has indicated that she will
Here.
be joining at. You are here?
There she
Yes,
is.
I'm here.
Oh, welcome.
Welcome.
I believe this is your first meeting.
It is.
Thank you so much for joining. Commissioner King
Present.
and Commissioner Simpson.
Present. And since Commissioner Carrion is not able to join us as vice chair, I'll be chairing the meeting today. First item is minutes.
Move to adopt.
That is correct. Typically, we just call to see if there's any changes by
Yeah.
commissioners.
Any changes or comments with respect to the minutes? Hearing none, seeing none. Is there a motion to approve?
And do we have any public comments?
Any public comments? Hearing none, seeing none.
So moved.
It's been moved and seconded. We'll call the roll.
Okay. I will just call those present. Commissioner B,
Yes.
Commissioner Carrillo,
Aye.
Commissioner Jenkins,
Aye.
Assemblymember Pacheco,
Aye.
Commissioner King,
Aye.
and Commissioner Simpson.
Aye.
So
Okay.
can I just, Commissioner or Assemblymember Pacheco, were you here at the last meeting?
I was not there.
So typically, if you're not present, then you abstain from approval?
I'll go ahead and abstain then.
I will note that for the record. Thank you so much.
Thank you.
Okay, next on the agenda is the report of the executive director.
Sure. So I know we've been monitoring SB 470, which is the bill authored by Senator Laird that would extend the teleconference procedures that we are operating under today. Initially, the bill would have just dropped the sunset date, but now the extension is through the end of the year in December 2029.
Okay.
And we will continue to monitor that and keep you updated. In the recent budget that was passed, the commission's budget, there were no changes, so we are happy with that.
Good.
Now that we have Christy, our chief of administration on board, she is working on some hiring issues. We have a vacant attorney 3 position that we're anxious to fill, and she's working on that. And since we provide administrative support to the Committee on the Penal Code Revision, they also have a vacant attorney position that we're in the process of filling. To get office space, which is a goal that I've mentioned before, we are going to need to get a waiver from DGS if we're going to be able to look for our own space. Another thing on the long list of tasks that we assigned to Christy when she arrived, we have been working on an update of the commission handbook. We're hoping we could have it on the agenda today. With the other workload, we weren't quite in a position to finalize it and hope to have it on the agenda for the next meeting. A lot of it will be technical, but some of it is making sure we're conforming to existing processes and looking to see if there's anything missing that we should have in there. So if any commissioners think there's something that they would like clarified, you can let us know. We continue to work with Christie on updating our internal policies and procedures. So we have sort of an official procedures manual, which will be really helpful for when there's any changing in staffing. We do have a website contract with, I believe, GoDaddy. So we are going to be revising or updating and modernizing our website. So you can look forward to that. We also, as a very tiny agency, we lack IT support services. So Christy and Sarah worked really hard in identifying some potential sources. We found a small company in Sacramento, TLC Tech, that will be assisting us and providing they specialize in apples, which is what we have. So that was a big bonus. And when our IT needs or issues pop up that are beyond our technical abilities, it'll be really great to have somebody on board instead of having to do it on an ad hoc basis. They also helped us with renewing our Microsoft licenses, so it was a package. Sarah has been working very hard with Megan on updating our conflict of interest code. It's a process I think that state agencies need to go through every couple of years just to make sure that all the right folks are designated, and it does have to go through the Administrative Procedures Act because it is a regulation. So that is my update. Are there any questions?
Hearing none, seeing none? Thank you. Are there any commissioner suggestions with respect to topic studies, whatever? Gone. Okay. And the next item, we moved up from the end of the agenda, the updating or extending the contract for our antitrust consultant. Sharon?
Sure. So Cheryl has been wonderful, and we're so fortunate to have her on board. The contract runs from one fiscal year to the other. We're at the end of the fiscal year, so we need to renew it so we can continue to access her great services in the upcoming fiscal year. Just for reference, that's memorandum 2025-33. So I guess the staff recommendation is to approve this. Are there any questions from commissioners?
Any public comment? Hearing none, seeing none. I will ask for a motion in a moment, but I would just FYI for Assemblymember Pacheco, since this is an executive action, you're not eligible to vote on this one as a legislator. So just FYI. Is there a motion to approve the contract?
I move the
So
recommendation.
moved. And is there a second? Second. It's been moved and seconded. You call the roll?
Sure. Okay, Commissioner B.
Aye.
I still don't see Senator Blake Spear.
You can't vote on it anyway.
Oh, that's true. Okay, so I will skip the legislative
There you
members.
go.
You just reminded
Yep.
me. Commissioner Carrillo,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King, and Commissioner Simpson.
Aye. And the contract is approved. Thank you. Legislative program.
Sure. We really, the memo is pretty much what you saw last time. That's memorandum 2025-24. There is a bill that would have required the commission to conduct a study related to judicial recusal. It is still in the House of Origin, I believe, in the Fiscal Committee. So theoretically, it's possible that come next January, the author's office could try to move the bill, they would have 30 days
Right.
to do so. So we continue to monitor it and we'll keep you updated. Other than that, we didn't have any more news.
Okay. Any comments or questions or from members? Or is there any public comment with respect to that issue? Hearing none, seeing none? Okay. Welcome.
Thank you.
Commissioner Kubas has joined us. Um,
The link that has the links on it, and it's also in your calendar, but I
I'm sorry. Yes. Assemblymember Pacheco, sorry.
No, nothing.
Oh, okay.
Sorry.
Okay, next on the agenda is the special order, but because of the, is it ASL translator?
Because we noticed it as a special order of business and we have the ASL translator, we cannot start until 10:30, but it's perfectly fine to go to the next item on the agenda,
Okay.
which I think is Sarah's.
Sarah, state and local agency access to consumer information. Item memorandum 2025-27. Sarah?
Good morning, Commissioners. I'm presenting Memorandum 2025-27 related to the notice of subpoena. This memo presents the draft tentative recommendation for approval as the final recommendation with one technical revision. The staff did not receive any public comments about the draft tentative recommendation, but in reviewing the recommendation, staff is proposing a technical edit to subdivision H of the commission comments. Does the commission have any questions or comments?
Any question? Yeah, David.
Could I make a minor technical edit? Instead of prior to, can we make it before?
Yes.
Otherwise, I'm fine with it.
Sarah, did you get that?
Yes.
Okay.
Thank you.
And okay, we're sort of,
So Sarah, are you asking for a motion?
Yes, does the commission approve the draft recommendation of the proposed revision with the changes proposed by Commissioner Carrillo for submission to the legislature and publication in the commission's official reports?
I'll move it with my change.
okay, I had a quick question. At some point, I recall that the DOJ had some concerns about the proposal. Are they still concerned, or have the changes we've made deal with their concerns?
They have not submitted a formal comment, but we agreed to some terms previously. And I did reach out to them specifically along with the other groups that I was working with on the language. And we did not get any formal
Okay,
public comment,
good,
but they
thank
are
you.
aware of the process.
Thank you. Okay,
Yeah,
there's been a-
and we have worked with them closely for several months now.
Got it. Okay, thank you. And there was a motion. Is there a second? Then moved and seconded. Call the roll, please.
Okay, Commissioner B?
Aye.
I don't see Senator Blakespear yet. Commissioner Carrillo?
Aye.
Commissioner Kubas, who joined us.
I'll abstain.
Sure. Commissioner Jenkins?
Aye.
Assemblymember Pacheco?
Aye.
Commissioner King? And Commissioner Simpson?
Aye,
Okay, thank
it's
you.
approved. All right. We're not quite at 10:30 yet. Item 6, Equal Rights Amendment.
Thank you,
Sarah?
Megan. I'm presenting Memorandum 2025-28 related to the Equal Rights Amendment. The commission received 5 comments in support of the draft recommendation from the California Women's Law Center, the National Women's Law Center, Planned Parenthood Federation of America, ACLU California Action, and Orthwine Law PC. However, in reviewing the draft recommendation, the staff noted we accidentally omitted a cross-reference to the existing Civil Code and Government Code sections as previously approved by the Commission at its January meeting. Upon further consideration, the staff is suggesting an alternate means of cross-reference that provides less disruption to the existing language. And although these amendments are technical in nature and unlikely to generate concerns, the staff is recommending resubmitting the draft tentative recommendation for public comment with the revision. Does the commission have any questions or comments?
Any questions or comments from commissioners? Seeing none, any comments or questions from the public? Seeing and hearing none.
Does the commission agree with the staff's changes to the code sections and recommendation to resubmit the draft tentative recommendation for public comment?
And so that would take a motion. Is there a motion to approve as most recently edited? Been
Second.
moved and seconded.
Okay, I will call the roll. Commissioner B?
Aye.
I still do not see Senator Blake Spear. Commissioner Carrillo?
Aye.
Commissioner Kubas?
Aye.
Commissioner Jenkins?
Aye.
Assemblymember Pacheco?
Aye.
Commissioner King? Aye. And Commissioner Simpson?
Aye.
Okay,
Motion's
thank you.
approved. Thank you.
Thank you.
We're still a few minutes away from 10:30. So let's go to item 7, terminology related to persons with disabilities. Steve, I believe.
There we go. Good morning, everyone. Apologize for needing to appear via video. I had a pressing family matter that I had to address earlier this morning, but it's nice to see everyone. This memorandum 2025-29 largely presents just another status report on the progress of this study and requires no action or decision from the commission. As a refresher, this study directs the commission, without substantively altering existing law, to recommend replacing the existing terms dependent adult and dependent person, which are used throughout the codes, with new terms that are more respectful to persons with disabilities, which is a group of persons included in the definitions of those terms. And the study also directs the commission to convene a working group with specified members to assist in that effort. As the memo indicates, we've convened the working group. We've had our first meeting. Some progress has been made discussing these issues, but we will still require at least another meeting, perhaps more, before the staff will have something to present to the commission relating to the feelings or conclusions of the working group. In the meantime, the memo identifies 2 potential problems the commission may eventually have to resolve in recommending replacement terms. There's certainly no, as I said, no decisions are needed, but if the commission had any preliminary thoughts on either of these issues, they're of course always welcome, definitely not required, but potentially could be of some help when the working group next meets. We could, throw those comments into the mix and see what people think about it. The first issue, as explained in the memo, I guess since we still have 8 minutes, I'll just talk about them a little bit here. There is something of a tension between the direction that we, that we find terms that are more respectful specifically to people with disabilities, while also coming up with terms which are broad enough to include other groups of people that are included in the existing definitions of dependent adult and dependent person. For example, one of those groups is a person who's an inpatient at a 24-hour health facility is a person who is included in most of the definitions of dependent adult or dependent person. At the meeting, in just addressing this most respectful criterion, the majority, I would say the majority of the participants fell back on person with a disability. There is this sense of being sort of specific without being, I don't know, like overly deferential or coming up with various terms that are not necessarily accurate and seem to be condescending. But the problem with that term would be that that might, at least on its face, exclude these other groups of people that are also included in the current definition of dependent person or dependent adult. And part of our instruction from the legislature is that we may not substantively alter existing law. So it could be a problem for us to have a term, a substitute term, which on its face looks to be inconsistent with how that term is defined. So we may have to work on that to find something which is broader than person with a disability. I also suspect that that was not, the legislature did not have in mind that that would be the term that we would use as a substitute, because people with a disability was in the charge to us saying, please find a term to refer to people with disabilities in a more respectful way. So if people with disabilities was the term they wanted, that could have just been done without the assignment. So I think they might be looking for something more than that. And then the second issue that I mentioned in the memo is that, and this is something which is often a problem when you do a study like this, there do appear to be several instances in which these terms, dependent person and dependent adult, are used in the codes without a specifically linked definition at all. That's maybe an oversight, or maybe it's not an oversight. Maybe it's intentional. It's hard to know. The context suggests that the intention would be to use one of the other definitions, but there are about 5 or 6 different definitions also. So that makes a little bit of a problem. And the issue here is that if we replace an undefined use of dependent person or dependent adult with some new term, that could be a substantive change to existing law. Because if there's no definition to the term, then right now the term is likely understood to mean something. I don't know. There might be some common understanding. Perhaps it's meant to be read, as it reads on its face, plain meaning. But if we use a different term, there is some risk that will cause some different understanding of the term. So, we may have to come up with some solution to that. We could, one thing that occurred to me, and this is just totally tentative, but we could add a provision to any of those uses if we recommended replacement that said, this replacement term is meant to be understood exactly as the term dependent adult or dependent person was understood, without saying what that understanding was. But in other words, we're not changing the law in any way. We are just substituting a term here. So whatever understanding you had of that term before, this term means the same thing. And there may be other ways that we can address that issue. So if anyone has any comments, and I think we have at least one member of the public who wanted to attend and hear this part of the presentation. So if anyone has any comments or suggestions about either of these issues or anything else about the study, they're certainly welcome. And I can take it to the working group when we next meet.
Okay. Are there any comments or questions by commissioners? Carrillo?
Thank you, Mr. Chair. Steve, I ran into a version of this problem once before, and I wanted to offer a thought, which might not be all that helpful. So I ran into this in the drafting process for Proposition 1, right to abortion in California's Constitution. And in the early stages, we ran into the exact problem you're having, which is getting away from the term woman, because that was arguably reductive and not sufficiently inclusive. All of the substitutes were terrible. Pregnant person, person capable of becoming pregnant, person with reproductive capability, and it got worse from there. The solution in that context, and this is where this is not super helpful to you, it was to reframe it away from who qualified for the right and just frame it in terms of the right itself,
Mhm.
a right that shall not be infringed. I don't think that solution helps you here. So I think you do need to confront the problem of crafting something that is sufficiently inclusive, but not derogatory. Me personally, confronted with that dilemma, out of a bunch of bad solutions, I think the least bad one is your point about qualifying person as defined in a subdivision with a definition.
Mhm.
I think it's a similar kind of dodge. It's a similar kind of solution. Because then you can do it in terms of characteristics, and you can be more inclusive without being reductive.
Right. And the other thing that has the advantage is that a term like that requires somebody to go look for the definition, because if you're saying
Yeah.
a qualifying person, you need to know how they qualify, what is
Yeah.
the basis for qualification. And so then it's a defined term for sure.
Yeah.
And that is
But then it does also solve the problem you have that, dependent and disability are not synonymous.
Right.
So, spelling out the different criteria to apply to those distinct concepts in this subdivision with the definitions like that, it enables you to do that. So I think it solves that problem too.
Great. Well, thank you. I appreciate that very much. Any
Is there a comment or question from any other commissioners? Seeing none, is there any public comment? Nobody has raised a hand either physically or electronically. Okay. So there's no action needed.
no action, no
on this.
decision? That's right.
Okay.
Just an
And I
update.
do want to thank you, Steve, for your nuanced analysis of this. It kind of reminded me of our landlord-tenant
Yes.
discussion, and it's very much appreciated.
Well, thank you. Hopefully we'll have a better result than where we'll actually be able to make a recommendation in this one. But yes, thank you.
Got it. Okay, thank you. Okay, it is now 10:31, so we can move back to Steve's other item, which is the recodification of toxic substances statute.
Yes.
And I would like to acknowledge and thank our ASL translator
Yes,
for being present. Thank you.
yes, much appreciated.
So thank you very much. So the next two memoranda, 2025-25 and 2025-26, present drafts of recodified provisions of the Health and Safety Code in conjunction with the Commission's long ongoing, non-substantive recodification of a lengthy chapter of the Health and Safety Code relating to toxic substances. The first, these memoranda, 25-25, just like the first memo that we present at recent past meetings, is only here on the agenda today as reference material, as it just presents a cumulative draft of all the recodified provisions that the Commission has provisionally already approved to date. Ultimately, we'll go into a tentative recommendation for you to then look at again. So this first memo, 25-25, again, requires no action or decision from the Commission. And unless any commissioner has any questions or comments, or a member of the public does, I'm happy to answer anything, or at least take a note of any question or comment, but there's no action or decision that's needed on that memo.
Okay, is there any question or comment from commissioners? Hearing none, seeing none. Any comment from the public? None apparent. So thank you, Steve. And
All right.
then the next memo.
Second memorandum, 25-26, is a draft of new proposed recodified provisions for eventual inclusion in a tentative recommendation. And for this memorandum and draft, the staff is seeking some action from the Commission, specifically a motion to provisionally approve inclusion of the items to go into a future tentative recommendation. And if the Commission does approve, then they will appear in the next cumulative draft that you see at the next meeting. As with previously presented drafts of what we're labeling next portion, most of the proposed recodification is routine. Typically, it consists of separating and then organizing very long code sections into individual code sections that are more easily readable. Sometimes otherwise organizing existing code sections in a way that makes them relate to each other and be more clearly relevant to each other. But in general, without significantly changing any statutory text at all, except for very technical changes. And in any instance in which there is a proposed recodification that involves anything more than that, the proposed recodified section is followed by a boxed staff note, which further explains the proposed recodification or identifies some drafting issue about which the staff is inviting public comment from people who might be able to offer such comment. And so again, if there are any questions or comments on this draft from either a commissioner or the general public, they are welcome. And then if not, I'm looking for a motion to provisionally approve the inclusion of these provisions in an eventual tentative recommendation.
Okay, any question or comment from commissioners? Seeing none, hearing none. Any public comment? Don't see any. Okay, is there a motion to provisionally approve this next set of changes?
So moved.
Been moved and seconded. Can you call the roll?
Okay, I will go ahead and call the roll. Commissioner B
Aye.
will be joining us later.
Okay.
Commissioner Correa,
Aye.
Aye.
Signed off for the moment.
There's a sound problem. I don't know if anyone else can tell. There's a sound.
I'm sorry. That was me, Steve. I think my mic was not on. So my apologies. I'll start from the beginning. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner Jenkins.
Aye.
I believe that Assembly Member Pacheco is not currently on. Commissioner King.
Aye.
And Commissioner Simpson.
Aye. And that matter is approved. Thank you, Steve.
Thank you very much.
Okay, the next item on our agenda is antitrust law. Just a few comments for the single. Okay.
I think that's. You're signaling me, Sarah. Did Steve have another memo? Oh, I'm sorry.
Oh, okay.
We can dismiss the ASL translator at this time, and thank you very much.
Thank you
for
so
your
much.
help.
Yes, much appreciated.
Thank you.
Okay. For the, in antitrust, for the single firm conduct memorandum, staff is first going to present the entire memo, and commissioners can ask questions or comments through the presentation. We'll take public comment after the staff presentation to make things efficient. After public comment, staff will walk through the decision points in the memo, and of course, commissioners can ask questions throughout that part of the discussion. If the commission decides to adopt language options with or without changes, staff will call the roll at each decision point. And alternatively, if the commission asks staff to conduct additional analysis and work on any of the options, no vote is needed, as it's simply direction to staff. We will obviously we'll be starting with the single firm conduct. And depending on the timing, we may need to pause for our lunch break, noon-ish. Okay? And
Okay, I'm
single firm conduct.
ready to go. My mic is on this time. So this memorandum presents language that you've seen before. It presents explanations about what the language is about that you've seen before. So I'll try to not be too repetitive, but the main purpose in the memo is to do a deeper dive into the public comments that we received relating to the last memo on single firm conduct. We did reach out to everybody on our listserv and our expert working groups to see if they had additional comment. As you can see from the memorandum, we did receive comments from a number of folks, including our single firm conduct working group. We also, in this memorandum, are trying to be responsive to comments from commissioners at the last meeting, specifically and including proposing mandatory codified language that was based on the legislative findings and declarations that you all saw last time. So as you recall, the last memorandum 2521 presented 3 options for the single firm conduct language that would be added to the Cartwright Act with advantages and disadvantages of adopting each. And then in addition to those 3 options, there were a list of various options on findings and declarations that would explain the statute's purpose and guide judicial interpretation. At this point, I'm not going to seek any decisions, as Commissioner Simpson said. But at any time, commissioners should feel free to interrupt with questions or comments. I would like to acknowledge that this is pretty, at least from a layperson's perspective, this is pretty complicated, a pretty complicated discussion and analysis, and that's why we're so happy to have Cheryl here today, Cheryl Johnson, to help us out on any of the more difficult questions. There are a number of potential decisions that the commission could make today, but the commission could also direct staff to provide additional analysis rather than making a decision on any of the particular provisions. As you can see, we listed all of the public commenters that we received. I would like to acknowledge that in a supplemental memo that we just published yesterday, there was a letter from the Chamber of Progress that we received in early April that is very similar, expresses very similar concerns to those raised by several of the public commenters who have concerns about antitrust reform. And so that is in the supplemental memo to 2530. And it does, in that supplemental memo, it does have a number of excerpts from that letter, just as we did in this memo. So moving along, the comments on option 1, the basic single firm provision, and that one, that's the option that it would just use the language that's very similar to Section 2 of the Sherman Act. I don't think we received any support for that option from a variety of views that we received, but a number of the, I would say, more business focused organizations, Cal Chamber, the California Life Sciences, and others objected to option 1 because of its tie to the legislative findings and declarations. And there is their concern is that the legislative findings and declarations would untether California from federal law. And so that's a common theme that you will see, and I can talk about that a little bit more when we get to the findings and declarations. I don't know if we agree that it's a complete untethering rather than direction to California courts, that California has its own statutes. The courts can interpret it with that in light. They can look to federal law, but they're not bound by it. And I wonder, Cheryl, do you have anything to add to that?
Oh, there we go. Okay. I think that's a very fair comment. We talk about untethering from federal law, but we're just simply saying you're not bound by federal law. You can look at federal law to find that authority that you think is persuasive and consistent with California law and interests and borrow selectively from it, but you're not bound to follow all of it. That's, I think, the intent with all of the provisions that seek to untether California law from federal law. And
So-
that is the current law. Our California Supreme Court in several cases has said our law, Cartwright Act, is very different from the Sherman Act, and we are not bound to follow federal law. We can look at it, but it is not binding on us in interpreting California law.
And keeping in mind that California currently doesn't have a Sherman Act Section 2 equivalent, in adopting something like that for California law, it's very important to clarify the point that Cheryl just made. And I think we are open to public comments on, okay, we heard what you said, but we're still concerned about the language. We'd also like the commissioners to look at it with that view. Let's see. I think that's pretty much all on option one. The single firm conduct working group did raise concerns that this option would not be effective. They think that, I think the language is fairly broad and would not be effective. And so is this a good time to ask for questions and comments from commissioners?
Sure. Questions or comments from commissioners regarding option one? Oh, yeah. Yeah, oh, yeah. Yeah, if I recall correctly, the only difference from the Sherman Act is having monopsonize in the language.
Yes.
Right?
Yeah,
Okay.
yes.
But other than that, it's the same as federal law. Other than
Yes.
that, okay.
And can I follow up on that? Am I correct that one of the concerns that's been expressed by various members of the commission and I think also the working group about that aspect of option one is that it can misleadingly suggest that California law is intended to be tied to federal law because we're incorporating Sherman Act so expressly, which would be the opposite of what we're trying to do.
I think that is correct. And that is one of the reasons we thought it was really important to have the supplemental findings and declarations from whatever form they ultimately take, so that it's clear that even though it's based on federal law, it should be interpreted within the context of California law. And I don't know, Cheryl, do you have anything more to add to that?
Yeah, I think the single firm working group objected to importing federal law because of the jurisprudence, not the language of the Sherman Act, which is very broad. It was passed in 1890, hasn't changed, but the court interpretations over the last 50 years, 40 years have been very restrictive. And so we now have the challenge that the basic law itself is fine, but we have all of these limitations engrafted by decades of jurisprudence that need to be distanced to give California more robust tools for antitrust enforcement.
And so to me, I think that the risk that's inherent in option one of making that problem worse than it already is, and that problem being one of the reasons we have this study in the first place, to me, that's a reason to forego further consideration of option one.
Okay,
Uh,
noted.
Commissioner B?
Yeah, so is there or could there be, as part of option one, the inclusion of the codified language that's further down in the report? So that it's clear that it does not adopt federal law?
So I think what you are referring to is the draft findings and declarations. And yes, that would be the idea if the commission thought that section one is the best option, that it could be accompanied by one or more of the draft findings and declarations to clarify that in interpreting this potentially new code section, they're not bound by federal law. They could look to federal law for guidance, but they would not be bound by it. And I see Cheryl nodding her head. Do you want to add to that, Cheryl?
No, that's complete.
Can I follow up on that?
Yeah, David?
Yeah, my concern about trying that in the context of option one specifically is that by so expressly borrowing from federal law, that the temptation for courts, especially federal courts, which is where this problem primarily lies and stems from, it would be irresistible for them to simply continue what they're doing, which is ignoring existing California exhortations to understand that our law is different from federal law and to keep applying federal law. So to me, option one effectively achieves nothing more than maintaining the status quo. And that's my problem with it.
Mhm.
Victor? Oh, I'm sorry. Go ahead. Maria?
Oh, and I just want to say, I don't disagree. I just wanted to be clear on what the options were with option.
Yeah.
Mhm.
Victor?
I agree with Commissioner Carrillo in disfavoring option one. I think the whole spirit of us incorporating these concepts into the Cartwright Act is that we are moving beyond federal law, but I take exception to the comment that it's untethering us from federal law, which seems to be hyperbolic to the extreme, because untethering is quite a strong word. But I think the whole spirit of this entire enterprise was to see what California can do to move the ball forward on antitrust, because we've seen such lackadaisical enforcement in general at the federal level, and in particular during the current administration. I disfavor option one as well.
Can I follow up?
Yeah.
I fully endorse everything that my colleague just articulated. But I think buried in there is a fairly nuanced point that that we would do well to keep in mind, and I'm going to unpack it here for the benefit of anyone who's listening, which is to a certain extent. So, for example, if we go with option two, to a certain extent, it's declarative of existing law and doesn't make any substantive changes in the sense that existing California law already says that California antitrust law is distinct from federal law, and California courts are not bound by it. And I think that's what's meant by the misleadingly reductive phrase untethering. We're already untethered from federal law when it comes to antitrust. So, I agree that it has some people's hackles up. Because they're taking it to mean more than it is. I think what actually we're trying to do here is make sure that California law as it presently exists is actually enforceable and gets enforced. I think that's the intent here. And if untethering gives the wrong impression, then maybe we shouldn't use that word anymore.
So I was going to say, my along that same theme, my assumption is that one of the reasons for doing something other than tethering is that if a court is looking at a case and looking at the law and looking at the guidance, statutory guidance that may be giving courts, they might be concerned that, well, yeah, I know it says we're not going to be bound by federal law, but if you wanted something other than federal law to govern this, why did you copy federal law? I mean, that the practical. Yeah, okay. Thank you. All right.
That is the risk. And if anything, I think that the real concern that we should have here is avoiding the opposite of untethering, which is lockstepping, which is a legit substantive term of art that describes a condition of the law where states intentionally lock their law to whatever federal law says on that particular subject. That I think the intent is to avoid. So that term, I don't think we should be afraid of using.
Thank you. Sharon?
We're ready to move on. Okay. Thank you for all those comments. The next option is option 2, which we refer to as the enhanced single firm conduct provisions. You have seen this one before as well. It combines it with a prohibition on restraint of trade, phrase used in both Cartwright Act and the Sherman Act. It's somewhat similar to option 1, but goes a little further. I will go back to, as you can see, there's a, on this one, there's just it looks like just a technical change related, a clarifying change, I should say, relating to what the term restraint of trade means. So we could talk about that more. A number of the comments didn't specifically address option 2, but the concerns that they raise, the general concerns they raise, would also apply to option 2. Both the California Chamber of Commerce and the Motion Pictures Association raised concerns about including the term restraint of trade in option 1. They were concerned that it could capture all restraints of trade, not just unreasonable ones. The Cal Chamber is concerned that common business practices, such as exclusive contracts that can be pro-competitive, would be per se illegal. We don't believe that option 2 does not declare any specific conduct as per se illegal, and instead would rely on established California precedent establishing the method evaluating effects and legality of the restraint. Another concern or another point is that as the concerted action working group noted, the California Supreme Court has held that the text of the Cartwright Act should not be interpreted literally. In Cipro, the court noted that although the Cartwright Act is written in absolute terms, in practice, not every agreement comes within the four corners of its prohibition have been deemed illegal. So again, going back to the theme of being consistent with California law. The California Life Sciences Organization also raised concerns about the term restraint of trade, but they also at the same time, and everybody will have an opportunity to comment. So we are doing our best to characterize your letters, but if you think there needs further clarification, you can absolutely do that in the public comment. But we read their letter as acknowledging that California already prohibits agreements in restraint of trade and does not create a new law with respect to collaborative agreements. A number of other organizations raised concerns about restraint of trade and that it necessarily infers and requires multi-firm conduct or is exclusively used to govern multi-firm conduct and shouldn't be used within the context of language relating to single firm conduct. I'm going to ask Cheryl to chime in on this one a little. But from the staff perspective, or the intent is that restraint of trade language is intended to refer to a negative effect on competition. And the U.S. Supreme Court has recognized that restraint of trade that term or that act can be performed by single firm conduct action as well as multi-companies. And so I'm going to ask Cheryl if she wants to comment on that a little bit.
Do I want to comment on it?
You don't, if I nailed it, no.
I think the argument is that people say, well, we use restraint of trade both under the Sherman Act and the Cartwright Act to refer to conduct by multiple parties. But the reason that the restraint of trade is used in both acts to relate to multi-firm conduct is because each of those acts precedes the use of the term restraint of trade with a requirement or a limitation that it be done by multiple actors. So there's usually two parts to the restraint of trade prohibition. One part requires multiple actors and one part talks about the restraint of trade or the effect on competition. And the case law is clear that restraint of trade doesn't inherently require multiple actors. It's a specific statutory language that require multiple actions. And restraint of trade is a more generic term for a negative effect on competition.
David.
On that specific point, so in general, my position is still that I'm in favor of option 2, and I'm still there. But on that point, I had a question, which is this is just effectively a conspiracy statute, and a conspiracy is an agreement with an act in furtherance. And the concern that I have in this context is that in a couple of places, the statute that we're incorporating by reference, if we go with option 2, 16720, in a couple of places, it talks about agreeing, and you can't agree with yourself. So I understand that case law says that you can do these things, you can violate the statute by yourself, but if we're incorporating by reference something that seems to expressly require an agreement between two actors, how are we going to write around that?
Yeah, 16720 does specifically require agreements or trusts, which are two or more people. So the statute, the Cartwright Act as written today, requires the restraint of trade be committed by either an agreement between two people or a trust, a conduct by two or more people. So we're just using the restraint of trade that is used in that section, but
It's just
we're
the
saying
acts.
just that effect on competition can be unlawful if done by one person.
Okay, that solves my problem.
Yes.
Any more?
The other, yeah, Victor?
Do you need a comment to clarify that, Bill?
I mean, it confused me, so.
Might be worth thinking about. I concur. I'm very much in favor of option 2. If you recall, I was the one who asked if there could be an option. I'm encouraged by the fact that you've given us some language that's favorable to the Cal Chamber and others about adding the word unreasonable. It could be an available request, because we're not here for the purposes of about unreasonable restraints of trade. I think everyone would agree to be reasonable. So I am in favor of option 2 because I view that as ratcheting back the option 2 last meeting, and I very much staff has created by prohibiting unreasonable. As superficial as that may be, is kind of a way to make it a 1.5 and not as unrestrained as.
Yeah, I think your point about adding subdivision B, that's what Commissioner B was referring to earlier about borrowing from these other state statutes. Eminently reasonable.
I'm having a little trouble hearing, I think it was Commissioner King. I can hear Commissioner Carrillo loud and clear, but I was having a little trouble with Commissioner King.
Perhaps I wasn't pressing the button. Is that better now?
That's great. Yes.
Okay, just to summarize my pontification, I was just mentioning the fact that at the last meeting, I was concerned that the option 2 we were presented with may have been too aggressive or may have been appearing to be too aggressive. And I sort of colloquially asked for, well, is there such a thing as an option 1.5? And the point that I was making was that I very much appreciate the additional language that staff wrote for option 2 that they're asking us to adopt, that you may reference to subdivision B. I think by adding the word unreasonable to the phrase restraints of trade, that's a great way to ratchet back option 2 to make it seem less revolutionary, as some people were implying. And I don't see how anyone can oppose the thought of adding the word reasonable. We're all in favor of reason, and no one's in favor of unreason. So that's why I do favor option 2 with the additional subdivision B language, saying the section is intended to encourage free and open competition by prohibiting unreasonable restraints of trade.
And Commissioner B, correct me if I'm wrong, but this is what you were referring to earlier.
Yeah, basically. I have a separate question then. So I think staff, I don't know if they recommended adding this language. This section is intended to encourage free and open competition by prohibiting unreasonable restraints of trade. So
I think they're asking if we want to add it.
okay. And Commissioner King, what is your, what do you think about that? Because you're saying that you would rather add unreasonable into the text of I guess, section A1.
Yeah, I think they've done that. The staff has specifically added the word, the adjective unreasonable in subdivision B, and that is the actual recommendation at the end of page 9.
Yeah.
So I'm in favor of that because that was what I was asking for at the last meeting. And if it passes the Cal Chambers scrutiny, that's also very impressive because they've tended to be a little skeptical of all our actions here.
Got it.
Okay.
Can I make a
Yeah.
comment? I'm just curious if why the staff felt to put that language in that particular place. Because typically, that type of intent language generally would be put in the findings and declarations section. And I'm just curious if there was some special reason why you're recommending that.
So I think that we are being responsive to some commissioners who would like to see things codified rather than having things in general finding and declarations. And in this case, and I'll let Cheryl chime in. I mean, there could be different ways of drafting it, and that we would like to hear from the commission. It's like, okay, we like the concept, but we want you to, fine tune this or that. So that's why we're here. But
I think
yeah, in this case, we thought it was important to be in the actual statute.
Because we can, as long as we're open to, I think it's a little misleading to be put where it is right now because it's talking about the whole section, but it's put in the subdivision. And so it could be put somewhere else. I think it would be more, be more applicable to the whole section.
Well, I think the law is very clear that unreasonable is read into restraint of trade. But we did worry about, because it's already read into the term restraint of trade, are we now talking about making unreasonable restraints of trade? Are we double unreasonably? But I just throw that out there.
Yeah, certainly something to consider.
Maybe just to help me clarify, are you proposing to put unreasonable in 16720.1 or in the sort of findings and declarations type part of the language that's later on in this memo?
So the suggestion would be to actually add that language to subdivision B of 16720.1.
Okay.
And so we, obviously looking at that language, there would need to, we'd need to do some wordsmithing to make that work, but just that somehow getting in that concept. I mean, as Cheryl said, in the antitrust community, restraint of trade is commonly recognized as unreasonable restraint of trade, that there's no intention to capture a broader universe. I don't know that this is the exact perfect language at this point. You know, and I think it's worth a discussion of, is it needed? Is it a red flag when it says in restraint of trade, but it isn't clarified that we mean unreasonable restraint of trade? You know, what's going to be helpful to courts and looking at things like this. Obviously, there's a well-developed body of case law that considers what restraint of trade means. Do you want to add anything to that, Cheryl?
I fully understand that there is case law. Sorry, I'm pressing the button again. From my experience, as I've mentioned several times, on spending 4 years on the mediation confidentiality law that couldn't pass due to the massive lobbying against it, I think we have to be attuned to the fact that we want this legislation to pass. So despite the ambiguities that are perhaps raised by adding the word unreasonable and people reading too much into it as thinking as that is a bigger change than it is, I think having the word unreasonable, if it brings aboard opponents like the Cal Chamber, it's partly a political decision, totally independent of the academic intellectual definition of restraint of trade. If you have the word unreasonable added, it's going to pass easier than if you didn't have it. And that's my practicality here. I don't want to spend years writing this and not have it pass. Furthermore, to double down on my favoritism of the unreasonable restraint of trade, they asked a simple, naive question, which is, why can't it be both in the declarations and in the statute? Because we really want to emphasize we're putting that adjective on restraints of trade. And again, politically, it'll make this thing pass much easier, I believe.
Yeah, I think I had a similar question to Kara, which is, if you put, rather than putting this section is intended to encourage by prohibiting unreasonable restraints of trade in B, rather than putting intent language in that substantive statute, why are we not simply changing the existing language to say it's something like it's unlawful for one or more persons to take or direct actions that create an unreasonable restraint of trade, or put the unreasonable up there in what is we're now saying is unlawful. As used in this section, unreasonable restraint of trade shall include but not be limited to yada, yada, yada.
So you'd put it in A.
So actually say it in the statute
Right.
as opposed to making it intent. That would be my thought.
But then
I'm
the
fine with that.
definition would be
Yeah,
needed.
then the definition, yeah.
Yeah.
Wouldn't make in both. So anyway, that was my
Hmm.
thought on that.
I agree with that.
Okay,
Okay.
more on option 2.
I think we actually got through all of option 2 for now. We can always come back to it. As you know, we will after we hear public comment.
Can I make a suggestion?
Sure.
Mr. Chair, to move the discussion along, it seems to me, and I'd like to hear from my colleagues on this, it seems to me like there's a consensus around option 2 with some wordsmithing, mainly in terms of how we phrase things and where we put them. But it seems like the commission is ready to move on from at least option 1. And if I can predict the future, I suspect we're also willing to move on from option 3. So if that's the case, can we actually take action on that? Reject option 1 and option 3 and move forward with 2 with amendments to be considered.
So I think it's probably more clear with option 3, but part of the reason we wanted to design it this way is we did have a number of public commenters and I can see several of them are present in the room, so that before the commission says, okay, this is the way we want to go, you can hear their oral public comments, you can ask them questions.
Happy to.
Yes, I
well,
would like to hear option 3, and let's not assume that we are unanimous.
Okay, fair point. So Sharon, option 3?
Okay. So option 3, exclusionary conduct provisions. So as we discussed in the previous memorandum, this option, which is largely based on the single firm conduct working group's excellent work, would represent a clean break from existing federal single firm conduct law and decades of restrictive jurisprudence. I think that was something that was chief in the mind of the single firm working group, is how do you craft something where it's really clear that judges, you don't have to keep doing this, not just in California courts, but for federal courts who are adjudicating something that is coming from California and looking at California law, but for various reasons, it's in federal court. So the option 3 uses new terminology and a different analytical framework. It draws on the exclusionary conduct provisions recommended by the single firm conduct working group, and it defines single firm conduct in relation to its harm to trading partners and balances against the benefits of the conduct. So you see the draft language, which you've seen before, and you can see that is different from options 1 and 2. The single firm conduct working group did submit a comment and graciously offered additional work if the commission would like to continue to work on this option. They do see it as a better approach, as reflected in their comment, and are certainly willing to continue to work with the commission and staff on this option. They also have some, very specific bullet points on why they think option 3 is a better way to go than the other 2 options. So we'd like to thank the single firm conduct working group for taking the time to give us that response. Let me see, what else do I want to say about this? Cheryl, did you have anything to add about the single firm conduct working group's comment?
Working Group 1 did add some clarifications. We had some questions how this new analysis would work, and they clarified that the second prong, which says does not provide sufficient benefits to prevent the defendant's trading partners from being harmed by that increased market power, that would be, they would shift the burden to the defendant to prove the entire part of that second prong. They also clarified that the benefits that can be used to counter the harm of the conduct can be benefits to those who the defendant has not dealt with directly. So it could be an indirect purchaser, for instance, somebody who's not dealt directly with the defendant. And I think those were some of our questions, but the exact operation and exceptions to this, because it focuses, the first prong says, has there been harm to a market rival? That's a different kind of focus than traditional antitrust analysis that looks to see whether there's harm to the consumer welfare or to competition. So it's a little different way of looking at it. Working Group 1 consisted of some of very renowned antitrust economists and experts who have been thinking for many, many years on this. Their work is also seen in Amy Klobuchar's federal legislation, the Calera bill, which has a very similar combination. So I don't have much to add to that, other than it is a new formula if we're looking to distinguish California law. It certainly would distinguish California law. That may be the upside, and it also may be a serious downside as well, because you don't know exactly how it's going to play out.
Questions? Yeah. Victor?
As we know from the prior meeting, no one was really in favor of option 3, and we were even thinking about abandoning it earlier than today. And I think I agree with Commissioner Carrillo's comment that we dispense with option 3. In some ways, your explanation was very helpful, that a bunch of very esteemed antitrust practitioners favor this one because, as the old saying goes, when you have a hammer, everything looks like a nail. And so they obviously would be probably in favor of more aggressive, more speculative, California forward-moving antitrust action than the marketplace will bear. Just my general comments, why option 3 is unacceptable to me. Looking at the larger picture, we have enormous uncertainty in the economy, tariffs, and other problems, trade budget deficits, trade deficits, and whatnot. I think to advocate for something that's this aggressive, option 3, is just adding tremendous uncertainty into an already tremendously uncertain world. And so that's why I would disfavor option 3.
I have a question for Cheryl, I think. You said that this looks at the negative effect on trading partners. But it doesn't speak to some of the other elements of the economy and society that the other options speak to?
Well, I don't think that Working Group 1 would say this really departs from a consumer welfare standard as it's understood in a kind of a full-blown way, that they are going to look in the first prong to see if you've diminished or impeded your rival. I mean, that's in the language itself. And then they look to see, do the benefits of that conduct outweigh the harm? So in that analysis, they would say that that does reflect a concern for the consumer's welfare.
Does this also reflect the, free and fair competition? I mean, I'm going back to, Adam Smith, and presumably the whole purpose of this is to have a freely competitive economy that results in innovation and efficiency and all that sort of stuff. This sounds more targeted toward the people with whom the defendant corporation, interacts, and I'm a little confused.
Well, I can't speak for Working Group 1, but I do think that they would defend it as a more efficient way of trying to determine whether conduct is pro-competitive or anti-competitive. I mean, because it is focused, and you can't have competition without competitors.
Right.
So, we often say, well, we only look at harm to competition, not to individual competitors. But that's kind of a little bit of a misleading proposition. I have a little concern that by making your first prong a harm to a rival, that you might incentivize disappointed rivals to be suing the defendants, and that it might cause a lot of litigation.
Oh, I see. Yeah. So if the defendant was more efficient or better quality products, and the rival didn't like that because they're losing business to a more effective competitor, they might go to court and say,
Right.
this is the,
And under this formulation, then, when the defendant got sued by the disappointed rival, the defendant would have to prove that his conduct provided sufficient benefits to prevent everybody from being harmed, the trading partners from being harmed. So that's a rather significant burden.
got it, okay.
I have a couple questions.
Yeah.
Mr. Chair.
Anna,
One is, did we have any comments from anyone regarding this option in terms of being in favor? That's one question. The second question is, can you take us back to kind of the impetus behind this particular option? And are there any existing state statutes that we modeled it after, or countries where we modeled it after?
So I'll go first, Cheryl. In response to the, did we receive anything in support? No, we didn't. And that was kind of, other than the single firm conduct working group. And that was kind of across the spectrum from organizations that are more business focused and looking at those kind of issues. Not everybody specifically commented on option 3, everybody in that sort of cohort. But the themes that they had in their letters would capture option 3. There's a lot about concern about in uncertainty because it would be new language. Courts would have to interpret the new language. And then as Cheryl indicated that, that could raise concerns about could this lead to new litigation as courts are wrangling with what the language means. And then so that's sort of the business side of it, but the groups that are more concerned about or are focused on labor and consumer welfare and those kind of interests also have concerns about the new terminology and different analytical framework from the expert report. So they also are recommending that the commission not propose an option 3. I will let, and hopefully Cheryl remembers the other part of the question, but I think is you were asking is where did this language come from?
Yes.
Yeah, and it came from the single firm conduct working group, a group of very highly skilled academics and other both economists and law professors who've studied this for years. So that's sort of the impetus. But I think part of your question was this based on any existing statutes that might be out there? I think the answer is no, but I will let Cheryl.
Either in the US or other countries?
Well, I think you will find cases that talk about the exclusionary aspect of conduct. And you'll find cases that say just about anything. I think in fairness, we're looking at their proposal out of context because they had 4 pages of guidance that accompanied this language, and we have used much of that guidance in some of the recommended preambles. Their concern was that to ask the courts to look at language that said don't unreasonably restrain competition or don't monopolize or monopsonize is pretty vague guidance, and the courts need more than that to determine whether the conduct is anti-competitive or pro-competitive. So this is their attempt to kind of look at the guts of what the courts are actually doing and kind of reduce it to different words. And then there was 4 pages of additional preambles and findings and guidance that accompanied this language.
But I do recall early on when we took up this issue, there was a conversation about what New York did and how the bill was dead on arrival. I don't know if this is kind of similar to that. And then we discussed something about European Union and how they look at competition. Anyway, that's what I was trying to get at. Like, is this completely invented and new, or is there precedent in terms of international law, domestic law?
I can't vouch for what the rest of the world does. The most of the state antitrust reform bills have not used this formula, and I don't believe New York does. It uses the monopsonize or monopolize language from Sherman Act 2.
So but this is the single firm conduct working group's proposal is not modeled on Calera, the federal proposal, or the New York 21st Century Act. Is that correct?
It does appear in Calera. The formula of exclusionary conduct does appear there.
So in part,
And in
yeah.
Calera, it is accompanied with a number of presumptions.
So I think that, the answer is they're drawing on their years of expertise, looking at what's out there. And certainly a lot of antitrust law is common law. It's built by the court. So there isn't necessarily a statute, but there's a lot of case law interpreting what this term means or what that term means. And to Cheryl's point, that their language was combined with a number of preambles. When we developed the language options relating to legislative findings and declarations, we looked at a lot of what the single firm conduct working group proposed in terms of, clarifying the parameters for California courts when they're interpreting, let's say it's option 1 or 2. It's like, here it is, and now here's some other things, court, that you need to keep in mind when you're wrangling with this law. Is that fair, Cheryl?
Yeah.
That helps me. Thank you.
And correct me if I'm wrong, but Calera is not law and looks unlikely to become law in the near future, right?
It's clearly not the law yet. It has been reintroduced this year.
Yes.
The bill was originally introduced in 1920 or 21 and was reintroduced this year. As to its prospects in Congress, I don't have a crystal ball.
Got it. Okay. Thank you. David?
If I could I ask a somewhat conceptual question that I think is inspired by option 3? You mentioned earlier, I can't remember if it was you or Sharon, that option 3 arguably reorients existing antitrust law's focus from consumer welfare to concern about the defendant's rivals. So I just wanted to ask, either from your own personal perspective or if you want to try to channel the working group, what do you think is the ultimate purpose of antitrust law? Is it to inspire a robust economy? Is it to foster business innovation? Is it to encourage competition, to squelch anti-competitive conduct? Is it to benefit the consumer? Is it to protect rivals? Like, what, if there's one sentence or one concept that encapsulates the ultimate purpose of antitrust law, what is it?
I think, as our California Supreme Court has said, we are here to protect free and open competition, and that free and open competition is considered the best way to promote market entry, better prices, more options for consumers. It's the best way to preserve our social and democratic institutions.
So if the purpose of existing law is to promote competition or protect it,
Yes.
Is it accurate to say that number one, that option 3 would shift the focus to a defendant's rivals, and that shift would be a substantial change in existing California law?
I can't really say what inspired that shift in focus. I think there is.
I'm asking, would you say that it is a shift in focus?
Well, it's certainly a shift in the way it is expressed. And a lot of people would say we've forgotten that competition needs competitors. And we've always said, well, inefficient competitors are just roadkill. But I think there's a growing concern that we're not sufficiently protective of maybe smaller competitors. I don't really know what inspired their change in focus. So let me leave it at that.
Okay. I mainly was trying to get at whether you agree with my perception that option 3 does represent a shift in focus of existing law. It sounds like the answer is yes.
I can't say.
Then that's worse. If you can't even tell me whether it's a change in existing law, that's worse than saying that it is a change.
The change in words.
I mean, there's laws that talk about the conduct that excludes competitors and rivals. So yes, there is law that certainly supports their enunciation of this principle.
I yield the remainder of my time.
I do have one last question or comment
on it.
about all the options. I know that early on we discussed the challenges of enforcement. And I wonder, of the 3 options, are any of them addressing the issue of enforcement? In other words, does our department, DOJ, I'm assuming, have the staff needed, the resources to actually enforce, whatever option we choose?
So, I'll try to field it and then see if Cheryl wants to chime in. I mean, I don't think we sitting here can say that we have knowledge of what the Attorney General's resources are. The Attorney General, and this is where Cheryl needs to be here, can take actions under Section 2 of the Sherman Act. So this is, it would be up to the Attorney General if they have their own California statutes about how they're going to prioritize what they look at, what they don't look at. I don't think we have anything specific to enforcement in the statutes as we've drafted them so far, and there's certainly nothing about resources of the Attorney General. So what do you say, Cheryl?
Well, I would disagree.
Okay.
I mean, I think by California having its own statute, it can use state courts to adjudicate disputes, and those state court judges are often more knowledgeable about local impacts. And also having a law that is a little bit more nimble than federal law will increase the opportunities for effective enforcement. If you're a state enforcer and you are limited to enforcing federal law in federal courts, you're going to think twice about bringing a case where the federal law has been diluted by judicial decisions, or you may have an unfortunate draw of judges. So this gives you other options, and so it should enhance effective state enforcement.
Thank you. That was helpful. I think I was a little too focused on the resources.
Okay, anything more on option 3?
I have a question. This
Maria.
discussion makes me think that it'd be helpful to have the AG weigh in, the state AG weigh in on whether it's the options or enforcement, but just to get their perspective on how the change in law will affect their work.
We have talked, the AG is not in a position to take a position on any of these options at this time.
But we will continue to reach out, and we would love to hear from them if and when they're ready to talk about the options, but we do agree that it would be helpful.
Yeah.
They're pretty busy with other stuff, you know, on the East Coast. Yeah.
Anything more on option 3?
Anything else?
Hearing
Okay,
none?
okay, hearing none. We're at about 11:40, so let's see how much more of this we can get through before lunch. As indicated earlier, we did receive a number of comments that were concerned about draft findings and declarations, clarifying how courts can use California law and how they can look to federal law as persuasive authority, but are not necessarily bound. So I'm trying very hard not to say untether. So, which I think, that isn't there's not an idea of a complete untethering. So we did receive a number of public comments along those lines. For example, Cal Chamber raises concerns that the draft findings and declarations are likely to outlaw common pricing and distribution practices that are generally viewed as good for competition. Also concerns with the language as it applies to predatory pricing and loyalty programs. And you can see that's all in the memo. I won't read their letters to you. I know they're here to talk to us all about it. The Motion Picture Association is also concerned. And again, the theme is it could create uncertainty because there would be new standards, and they're reading what the proposed language would do is reject, decades of jurisprudence on single firm law, and notes the statute was created in 1890. So, the concern is the enormous uncertainty and its impact on pro-competitive conduct. But in looking at this and consulting with Cheryl, our view was that it's not borne out by the long history of California's adoption of antitrust provisions that are distinct from and often stricter than federal law. And again, not to use that word again, but the untethering is not intended to be a wholesale rejection of federal jurisprudence. The intent is to allow California courts the flexibility to adopt federal case law it finds persuasive and consistent with California law and interests. On the flip side, the folks who really like option 2, it's a number of organizations that have joined together and in one joint statement adopts recommending the enhanced purpose statement, which we will get to in a minute. So that's sort of the overview of what the broad strokes of concerns are. There's a number of folks who are really concerned about what exactly the draft legislative and findings and declarations would do with respect to federal jurisprudence and how that's used by California courts. And then on the flip side, folks saying, yes, this would be really helpful to, stuff like this would be really helpful to California courts in applying whatever new option the commission chooses to go forward with. So not unlike the options for single firm conduct language, we had proposed something basic, a little more, and then a little more. So the first one is the basic purpose statement, which would simply be a legislative finding and declaration that the promotion and protection of free and fair competition is fundamental to a healthy marketplace that protects all trade participants, including workers and consumers, and to an environment that is conducive to the preservation of our democratic, political, and social institutions. And in crafting that language, we actually did look to the California Supreme Court case, in re Cipro cases 1 and 2. So that finding and declaration from our perspective is consistent with existing California law. We did not receive any comments that were specific to the language. One thing, since this is a basic purpose statement, one thing to keep in mind is, would this particular language be necessary if, for example, the commission was more inclined to do something along the lines of the enhanced purpose statement? So since that was one particular segment, I'll ask if there's any questions or comments.
No, not
Seeing
any.
none?
Nope.
Okay. So the next one that you all have seen before is in the enhanced purpose statement. In drafting this statement, we look to the provisions of ACR 95, which is the resolution that directed the commission to conduct this study. The proposed New York 21st Century Antitrust Act and the CALERA, and we were specifically directed by ACR 95 to look at the New York 21st Century Act and CALERA. And we also went through the working group reports, and a number of them were really helpful in coming up with ideas on how to describe the harms of unrestrained anti-competitive conduct and the need for reform from an economic and legal standpoint. And so this language is a little bit more than what was proposed in the first basic purpose statement. We did receive specific comments from the joint organizations, which include labor and other more consumer-focused interests. In March 28, 25, they urged the commission to adopt and recommend to the legislature the enhanced purpose statement, as well as the other language that we're going to go through. As I summarized at the outset, there are a number of groups who are really concerned about the draft finding and declarations or purpose statements. The same concerns or the concerns that they express would also apply to this proposal. And so at this point, since this was another idea, I wanted to break and see if the commissioners have any questions or comments.
Yeah, David?
Yeah, again, I don't want to speak for my colleagues who might be undecided on this, but if we're going with option 2, I think we have to think about doing the changed language in option E that's on page 19, because that'd be consistent with adding the unreasonable restraint of trade language. It clarifies that. So if we do one, we have to do the other. Again, if we go with option 2.
Other comments?
Any other
I had-
questions or comments?
Yeah, I had one. Number one, I think subdivision D is sort of functionally the same as subdivision A. They're both about labor workers. So that seems to me to be not necessary. In subdivision B, consolidation, accumulation of market power. it doesn't, it suggests that creating a dominant firm in some market is in and of itself bad. But it seems to me that a business that accumulates market power because they're better at what they do than their competitors ought to be okay. That's sort of one of the reasons we have competition in the first place, that you try to, create a better mousetrap and have a bigger and more successful business. So I'm concerned about market power that is accumulated because you're better at what you do than everybody else versus market power that's created because you're doing things that are harmful to your competitors. I understand there will be nuances to what is and isn't harmful to competitors, that sort of stuff, but this seems to say market power consolidation in some marketplaces in and of itself is bad. So I'm concerned about that.
Sure. Understood. I think that's something, these suggestions or comments will certainly cause us to go back and look at the language. I would like to hear Cheryl's comment or reaction to that. I would say these are findings and declarations.
Yeah,
I don't want to get too far out here, but could there be something about the, something about pro-competitive benefits versus anti-competitive benefits?
No, but I think Commissioner Simpson is focusing on the word accumulation of market power.
Okay.
Obviously, to the extent that one becomes dominant through superior products and better competition, that's all to be praised. It's not to be condemned. So I think it's an excellent point that we really are talking about the unreasonable leveraging of the market power into other markets.
The
So
use of
it's
market
the
power.
leveraging, it's the use of market power to expand their footprint. So maybe we should work on the language of that to better capture that
Okay,
concept.
but that sounds like then this ought to be a conversation for the abuse of dominance conversation we're going to have later today, rather than simply in the single firm conduct.
Well, even when you talk about attempt to monopolize, I mean, parties, you can have a monopoly if you've acquired it by competing
Bad
on the
behavior.
merits.
Yeah, okay, yeah.
It's only when you are not competing on the merits that you are doing exclusive contracting that forecloses a very significant part of the market, or engaging in some other tactics that unreasonably hurt your rivals.
Okay.
And hurt competition. So I do think that we should re-examine that wording.
Okay. And then, yeah, okay.
Perhaps
Vicar.
another way to skin that cat. Okay, perhaps another way to skin that cat is to not shift the focus to use, but with just the adding of the adjective excessive accumulation of market power or something along those lines be helpful. Because no one's opposed to market power, but it's the excessive accumulation.
How would you define excessive? Because I agree with the concept of, what's wrong with having a single firm? They do great things. It's their behavior. Once competitors come in, that is the bad thing, right? Because it's their instinct to stay number one and the only one. I mean, that's just my philosophy about this whole thing, but I'm not sure about your suggestion about the language. I don't know if I agree with that.
Yeah, I'm not wedded to that suggestion, but I'm just wondering what Pandora's boxes we're opening by adding the concept of use, because that just broadens that concern in a way, in a totally different direction. Then it sounds like a good fix to describe use as being what we're concerned with, but it really just opens it up in a way that may be too broad for me.
Right, and we'll be discussing that in the, the other memo.
Yeah, and to that point, I think one of the things the commission will need to think about is does the commission really want to do something that's specific to misuse of market power, or are there ways to address concerns related to that in the context of the single firm conduct language, maybe merger language? That's something that we would need to talk through.
The other comment I had about this and the first part was and I guess I can get more specific after we've sort of had our public input and conversation. I think whatever we're going to do of these pieces ought to be part of the Cartwright Act, probably the first article of the Cartwright Act, and ought to say, rather than the legislature finds and declares that the promotion, it ought to say something like, the purpose of this chapter is the promotion and protection of free. So as opposed to someone's, in this case, the legislature's thoughts about what is right or wrong, the statute itself ought to be saying, this is our purpose. Not that's a legislature's purpose, but who cares what, right? That there are other statutes, so as a statutory declaration of what the purpose of this chapter is. Anyway, I'll shut up for now.
Okay, any more questions or comments on this part? Okay. Moving along, let me make sure oh, okay. Yeah, I turned the page too quickly. So the next one is a statement reflecting California's laws, preferences, and priorities. You've seen this language before. In the previous memorandum, we noted that the Consumer Welfare Standard Working Group report identified two unfounded principles based on Chicago school narratives that have limited the strength of antitrust law, specifically looking at complicated concepts like the false positive framework, the presumption that vertical arrangements and unilateral conduct are likely to harm competition, and having eroded the capacity of antitrust law to protect competition. So the idea with this language, and we also included some revisions based on commission feedback at the April 3rd, 2025 meeting, is to codify and mandate the interpretation of California's antitrust law. We clarified subdivision D. One of the comment, or several of the comments are directed at or suggest that things are new. One of the things we did for the commissioner, so they can understand where things are coming from, is that we added footnotes just for the purposes of this memoranda to subdivision D, so you can see where it's coming from California case law to address concerns that the language is new. I think it's really helpful to be able to do that whenever we can, and when it comes time to actually write things or we get closer, it would be helpful for any comments that the commission may have as well. So we took out the legislature hereby finds and declares because the direction that we were given by the commission is to put it in statute and make it mandatory. So that's what some of the suggestions are at this point. The first change in subdivision A, Professor Tom Campbell submitted a comment relating to what the courts have said about deterrence. And so saying that California favors maximizing deterrence of antitrust violations is intended to address that comment. We hope we got it right.
And that's in lieu of, we prefer over enforcement rather than under
That's
enforcement.
right, yeah, which unfortunately, it's supposed to be showing a strikeout and add in the draft, but somehow the strikeout got deleted.
Got
So
struck out.
thank you. Thank you for that. In subdivision B, consistent with the discussion we had earlier about the use of restraint of trade, we suggested inserting unreasonably before restraint of trade. And also clarifying that in what we're talking about here should be subject to antitrust scrutiny. Subdivision C has some more clarifications relating to the 2023 merger guidelines issued by the U.S. Department of Justice and the Federal Trade Commission. And the idea is giving courts direction to look at those merger guidelines and to harmonize them, harmonize their rulings with the guidelines when construing this particular section, but to the extent consistent with California laws and interests. And, we hope to get all kind of ideas about how this could be better written from the commissioners, but that's the concept. An alternative to have sort of this reference to the 2023 merger guidelines, which is a specific point in time. So it's something, regardless of what happens in the future, it's something that the courts can look to and say, this is what the merger guidelines said. The alternative would be taking merger guidelines, what's in merger guidelines, and putting them in statute. I don't think, since we're not saying you have to necessarily follow them, but you should be looking at them and harmonizing their rulings to the extent consistent with California law. So I'm not sure that would be a better approach, but the staff could certainly do more analysis and give more information to the commission about how that works. And subdivision D is the one where we added all the footnotes to reflect and made some technical corrections, but so the commission knows, here's the case law where this is coming from, here's what some of our working groups said about why language like this is helpful. And then the last one, again, trying to go back to that concept of federal law is not binding on California courts, but clarifying that courts may consider federal law persuasive authority to the extent consistent with, and we have persuasive in there twice as I read this, to the extent consistent with California laws and interests. I think some of that we would want to tweak some of this language based on what we've already heard about other things. We have the note here from the very helpful comment from Professor Tom Campbell. I think, you know, again, we had a number of organizations that are concerned about the findings and declarations in general. I think their concerns would equally apply to this. Maybe, maybe not. We'll hear from them. Some of the suggested changes address their concerns. And then on the other side, the other organizations who support antitrust reform had previously urged the commission to adopt the various, I think the findings and declarations, for want of a better word, that we've gone through and will go through to the end of the memo. So I will break now for questions and comments.
Questions? Yeah, Kara.
I just want to clarify that I think we're trying to make a distinction that this is not a findings and declaration. Is that correct? But
That's correct.
it seems to me that this isn't language that we're outlining a specific law for people to follow. It's more guidance, and it might be more appropriate to codify the findings and declarations in the statute rather than having it be like proposed provisions of the statute. It's just a technical thing.
And just one, and that's an excellent point. You know, we got as far as we could with stuff, but that's an excellent point. I think there are some places where the language says the word shall, so I think we would need to take a closer look at whether this is like something that is directing courts, this is how you shall do X, Y, and Z, and whether that language should appear along language that's more akin to guidance.
Right. I agree.
Victor?
Yeah, I have a comment. I find two parts really problematic in this language, and unless we change it, it shouldn't be in the statute because I think it puts the thumb too much on one part of the scale. In subsection A, I just have a visceral reaction to the word maximizing. That sounds rather aggressive. You can maximize antitrust violation deterrence by saying that no business should be more than $250 billion in valuation. I mean, maximize is a little unhinged. So I'm thinking of a different phrase, favors robust deterrence of antitrust violations. I completely agree that it was silly to say we like over deterrence rather than under deterrence. That's just too conversational. But to say maximize is just a red flag to me because we don't maximize things and take things to the extreme. And that's what the word maximize implies to me. So maybe a word like robust or something like that. In subsection subsection E, I don't like the phrase that federal law shall not be binding on California courts. You can make the point without that preface. You could say California courts may consider federal law persuasive to the extent they find it persuasive without making a bold declaration that federal law should not be binding. I mean, Marbury versus Madison, I mean, the Constitution. I mean, there's all sorts of things that are inherently binding on California law. And I think the latter part of this.
Now that I'm looking at it.
The latter part of that sentence completely captures the concept that our hands won't be tied, but we shouldn't have declarations in our language saying we don't find federal law binding.
You could partially solve that problem by just saying federal law is not, because that's just true in this area of the law.
I understand that concept, but I don't want to necessarily, again, reflecting back on people worried that we're being untethered. We don't have to say that.
Well, maybe you could say, federal law on the subject matter of this chapter shall not be binding on. So it's the antitrust law is what you're talking. So maybe as explicit.
That's another way to do it. But just the broad statement that federal law is not binding just kind of set me off.
Right. We just declared our independence.
Exactly, exactly. But rather than say on the subject, you could just also go with just the latter half of that sentence. That federal law is will be persuasive to the extent it's consistent and persuasive.
And that-
Without having to make a declaration about how.
So just strike the whole first clause.
Yeah, and I know Cheryl wants to talk, but I think part of the concern, and maybe it's the part of the concern is that courts are currently interpreting things in a manner where they're assuming it is binding, and if there isn't something that's clearly pointing courts, especially if something's in federal court and they're applying California law, that they're not bound by the federal precedent, then that could be an ambiguity. And I know Cheryl can say this better than I just did, but
So I want to say, yes, that addresses a serious problem we have in interpreting the Cartwright Act cases. If they're pled along with the Sherman Act cases, they're typically in federal courts. And even if they're just pled as a Cartwright Act claim and they're part of a class action, they're in federal court. And the federal court, despite the fact that the California Supreme Court has said not once, not twice, but at least 3 times, federal law is not binding. Our law is different. We are not based on the Sherman Act. I can't tell you how many cases come out from the federal courts that say, oh, the Cartwright Act is modeled on the Sherman Act, and so goes the Sherman Act claim, so goes the Cartwright Act claim. So this is really to reinforce that the courts shouldn't just follow the Sherman Act, even though it's existing law. But let me address Commissioner King's criticism of the word maximize, which came from the mouths of the California Supreme Court. that actually is drawn from the Clayton case. The Consumer Welfare Standard Working Group talked about 2 frameworks or analysis narratives: the false positives framework and the horizontal. The vertical mergers don't create harm. And these kind of themes underlie a lot of the restrictive Chicago school thought. Now, the false positive framework says, oh, well, the cost of over-deterring or claiming that conduct is unlawful when it's really not is so high that we should avoid enforcing. So that framework favors under enforcement. So I don't know how you say, our law favors under enforcement. When you put the burden on the government to prove everything, you are putting a thumb on the scale and saying we want the government to prove everything, and we're also going to add these heightened burdens of proof. So California antitrust law, first of all, we say if you violated the antitrust laws, you're going to pay treble damages. You're not going to just, pay once. You're going to pay 3 times. So that's part of our law views enforcement of antitrust violations so serious that we're going to impose treble damages, which is fairly rare in California law. In our California antitrust case, we rejected the U.S. Supreme Court's decision in Illinois Brook that said only people who deal directly with an antitrust violator can sue under federal law. We said we don't buy that. We're going to let anybody who is harmed by an antitrust violation to sue. We don't care if the violator is subject to multiple suits. So in many respects, our antitrust law favors what one might say over-deterrence, or one might say maximize enforcement, maximize deterrence. I don't know. But I think that's kind of the concept here.
I appreciate the concept. I appreciate the reference to the California Supreme Court decision if you are just quoting them. But again, the word maximize just bugs me. Yeah. So, you know,
I've similar
I
concerns.
I don't think we could do it from the dais, but just think, I'm just wondering if there are other words: robust, serious deterrence of antitrust violations, active deterrence of antitrust violations. Just maximize in and of itself is problematic, despite the fact that the California Supreme Court said it. Because again, you can maximize preventing antitrust violations by saying no company should have market cap of more than 250 billion. And then you can't have a Visa, you can't have a Microsoft and whatnot. That would be maximizing, preventing antitrust violations, having small companies.
Okay, any other comments by commissioners? It's about noon. This would probably be a good time to break for lunch. Come back at 15?
1:15. Oh, that's an hour. Want to do like
45 minutes?
45 minutes?
Okay, come back at 1 o'clock.
Oh, do you want to, Anna has to leave at, she would prefer 30 minutes.
30 minutes? 30 minutes? Sounds good. Okay, come back at 1:15.
Thank you.
We are in recess. Thank you.
Yeah. Is there a place? Well, I'm jet lagged, so.
There's a cafe right across the street.
Okay. We are back in session. And I believe we're now still in the single firm conduct memo part rejecting federal precedents.
Yes.
Okay, page 19.
Yes, we're on page 19, statement rejecting specific elements of federal precedents. And I will say that a lot of this we drew from the single firm conduct working group report. The idea is that there are certain cases out there that have been criticized, federal decisions that have been criticized. Brooke, Trinco, and Amex, and they prohibit reliance on, oh, and it also prohibits reliance on 3 additional approaches limiting antitrust enforcement. So in speaking with Cheryl, I think that one of the issues is not just necessarily the cases themselves, but how they've been interpreted in subsequent decisions. So that's something to keep in mind. So basically, these are findings and declarations again, and they're disavowing certain concepts that have been raised in the cases that we've been talking about, and then subsequent case law. This is all language that you've seen before. Let me see, did we make? I think in subdivision I, we made more of a clarifying change to that. I think all of the concerns that we've already discussed, so I won't repeat them, also apply to this particular language. Again, there is a group of folks that are pro-reform who are supportive of the commission adopting language like this. So that's sort of the high-level summary
Okay.
at this point.
Questions or comments by members? Maybe I don't know enough about this, but it strikes me that if we're basically rejecting specific stuff that were findings of these three cases, wouldn't that sort of imply to a California court that other findings in other cases aren't that bad and maybe ought to be relied on? And so I'm nervous about saying any of the about this stuff in the first place. So, Carrillo?
Yeah, I liked what we were doing in the previous section, and I think that if we do option 2, we have to include language like that in the previous section. So to me, that then rules out or moots the question of whether we should do these specific rule outs, because we'll have the general
We have
rule
a
out.
generic, yes.
Yeah.
general,
Yeah. So
That's my thought too.
if we do the more general statement, I don't see the need for these more specific ones.
Other questions and comments?
Cheryl, did you want to add anything to this one?
No, I think these pretty much come word for word from our working group 1 recommendations, and most of them were also drawn from Calera and are kind of consensus cases where a lot of people are critical of certain elements of the cases. And this simply says that you can look at these elements, but we're not going to require that they be proven to have a violation under California law.
Okay.
Any more comments?
Comments or questions? Hearing none? Moving on.
Okay, so then we had some comments that didn't neatly fall into the buckets that we were just discussing, but we wanted to make sure that you were aware of them. The organizations that support antitrust reform actually didn't submit a public comment. They previously had submitted a public comment that was responsive to the single firm conduct provisions, but they had done their own analysis and report and recommendations. And one of the interesting things that they're proposing that we have not discussed before is that they're suggesting that another approach to providing guidance on California antitrust law reform is to grant the Attorney General rulemaking authority. So we have a quote from their report, saying the Attorney General currently lacks that authority, that the state Attorney General is, somewhat similar to the FTC having that role at the federal level, but the California Attorney General would have it at the California level. I mean, they're certainly experts in this area, being the chief enforcement officer of it. So it's really an interesting proposal. Like we indicated earlier, at this time, the Attorney General is not in a position to comment on any of this. It would, we would certainly love to talk to folks about that if and when they're ready to do that. We think that would be an important conversation if this is something that the commission would like the staff to provide further analysis and recommendations. I think, it's one thing to say the Attorney General should have rulemaking authority. What that includes, what language we've already looked at, how that would be presented. Would they just be making rules based on that? What exactly would the parameters or the direction be for that rulemaking authority? Rulemaking is a lengthy process, especially for something like this. They would have to, having done it before, they would have to have public hearings and get public comment, have drafts. They would have to respond to public comments. And so it's a series of events that get you to the place where, or an agency to the place where they finally have something to present to the Office of Administrative Law. And then the Office of Administrative Law does all their analysis and, follows all their processes. So it's not something that could certainly happen overnight, and probably not something that could happen without resources to fund the effort. Yeah, we'll come back to this when we go over the specific questions, but does anybody have any
Anybody?
comments?
Staff
this
comments or
time?
questions at this time? Hearing none, seeing none. Okay, let's move on.
Okay, the Motion Pictures Association and the California Life Sciences Organization, I think because of the nature of the kind of work they do, raised concerns that there could be a conflict between patent law in the case of the California Life Sciences and copyright in the case of the Motion Pictures Association. We did work with Cheryl on this. We reviewed a lot of literature on the issue. And at this time, we don't think that there's nothing that overtly addresses copyright or patent law. So we don't think that the language as drafted now creates a conflict. And so we've cited, we've done some analysis on this. Yeah, and then, it's a complicated set of analysis, but we do cite to some cases. It's in footnote 43, the Viva case, I think that really nicely sets out the different kinds of federal preemption that there could be: express, conflict, obstacle, and in the field. So, we're not seeing anything expressed, and I'm going to let Cheryl talk about this because I understand she may have had a hand in helping write the patent section of the antitrust law treatise. But we don't think that there is an issue after reviewing this very carefully. And Cheryl, do you want to add anything to that?
No, I just think from the language of the copyright law and the patent law, there's not any kind of express preemption of antitrust laws as long as they are not attempting to offer patent-like or copyright-like protections, and there's nothing we've proposed that comes even close to that. So I think there always could be a case where there might be some sort of conflict preemption, but those would be determined on a case-by-case basis. And it's kind of hard to envision a case where it's going to be impossible to comply with the state antitrust laws and the copyright laws at the same time. There was a case cited by, I believe, the MPA that said where Pennsylvania, I believe it was, had adopted a law that said after, I don't know, for a period of time, they were required to do certain things in licensing the copyrighted material. And the court did find that that was in conflict with the rights that one had under the copyright law, but they dealt with that as a conflict preemption. And obviously, our law is nothing like a law regulating how you license copyrights.
And so there is already a robust body of case law for courts to look at, if in some particular instance there is an issue. We're not seeing at this. I know that I think I see both representatives from the Motion Pictures Association and California Life Sciences here today, so I'm sure they can speak to it. Are there any questions or comments?
Comments from members? I don't know enough about this sort of stuff. Is this the kind of thing where perhaps what we write for a new statute ought to keep it out of the way of copyright laws? Or I don't know. Anyway,
I don't think we need to.
Hmm?
I don't think we need to.
Okay, okay,
Yeah.
all right.
Okay,
And last but not least,
last but not least, the ICLE is one of the organizations that had general discomfort. On many occasions, they expressed concerns about what the commission is doing. But interestingly enough, they called out the term monopsony and stated that there's currently a lack of consensus on what the fundamental issues are as a market definition, competitive effects, and how to balance harms to workers versus consumers. They pointed to the working group. We pointed to the working group on concentration in California, which I think, basically makes the point that, yes, it's appropriate to include that language within the statute. And additionally, over time, the commission has received numerous public comments on the importance of addressing monopsony power and specifically using that term in any draft legislation. So I don't know, Cheryl, did you want to add anything to this one?
Well, just to clarify, I mean, the law has always included attempts to monopsonize or monopsonization, because monopsony is just a subset of monopoly. It's just a monopoly on the buyer side. So it's just a kind of monopoly. But historically, I think a lot of advocates for workers' rights have said there's really been very little enforcement against buyer side monopolies. And so there's been very little protection of workers' rights. And they feel it's very important to include monopsony, even though a lot of people think it's kind of redundant, to emphasize that we recognize that all of the market participants, including labor, are protected by our antitrust laws.
question or comment from commissioners? Hearing none, seeing none? Okay. Now it's time for public.
So I think it's
Yeah.
time for public comment, but I'd kind of like to get a read on how many people we have on queue who might want to make public comments so we can set some parameters on how much time we have. One hand, and we have how many in the room?
How many hands in the room?
We have
1, 2,
four.
3, 4.
4.
Okay.
So that's, I mean, that we could
Okay.
give them 10 minutes each.
Yeah.
Just that they put a lot of effort into this.
10 minutes?
So
Roughly 10 minutes.
roughly 10 minutes.
Good afternoon. As I think the commission knows, my name is Eric Ensign. I'm an antitrust attorney with the law firm of Kroll and Mooring, and we are proud to represent the California Chamber of Commerce in connection with this matter. I've got to start by commending the staff for its work on Memo 25-30. Clearly, a lot of effort went into it. We still have serious concerns with the proposals set forth in the memo. So I will begin where I always begin, which is the fact that there is no economic study demonstrating that California's antitrust laws are failing or that there is a need for revisions. There's just no analysis suggesting that Californians are paying more than they should or are suffering from a lack of competition because of gaps in California's law. There's also no commission study measuring the costs associated with the revisions to California law as suggested in the staff memo. Now, I know the commission at our last meeting asked questions about whether these types of studies are even feasible, and they certainly are. In our May submission, we listed the economic firms that do this kind of work and how these types of studies can be conducted. We also identified the economic studies that have been provided to the commission that can have concluded that new antitrust laws like these may have a tremendous impact on the state in terms of lost sales, lost jobs, and lost tax revenues. Now, I know there are some who say it's too much work, it's too expensive, it's going to take too much time, but we have to invest, in our view, we have to invest the effort, expense, and time to study these issues so that this body can decide whether changes like this are necessary, and if so, what they're going to cost. I'd like to quickly cover some of the discussion from earlier this morning about option 2. The first point I'd like to make is, and I know the Commission is aware of this, unreasonable restraints of trade are already prohibited by the Cartwright Act. Now, it's true, it requires more than one party to violate the law with respect to restraints of trade, but the harm that arises from restraints of trade is already covered by the Cartwright Act. Second, we've all been focused on the restraint of trade language that's in option 2, but option 2 is not limited to restraints of trade. It also includes bans on restraints on the, quote, free exercise of competition and the freedom of trade or production. These are brand new legal terms. They have never been interpreted by a court, as far as I'm aware, and I have no idea what they cover and what they're aimed at. Third, it is true that there's a fair amount of law describing and interpreting what an unreasonable restraint of trade is. All of that law relates to multi-party restraints of trade. None of it relates to what is an actual single firm unreasonable restraint of trade. And that brings me to my final point on option 2, which is, short of monopolization, I have no idea what an unreasonable single firm restraint of trade is. I would not have an ability to advise my clients on what it can or what it can't do when it comes to this law, because I don't know what it bans. So whatever clarity we can get from the Commission or from staff on the type of conduct that's covered by a ban on single firm unreasonable restraints of trade would be incredibly helpful so that businesses can then act accordingly. Finally, I'd just like to quickly address the sort of tail of the last discussion, which is the idea of adopting language that nullifies certain Supreme Court cases, in particular, Brook Group, Trinco, and Amex. These cases are some of the most important economic and legal principles that have guided courts for years. Brook Group, for instance, in that case, the court clarified that predatory pricing claims must be supported by evidence that, 1, the defendant priced below cost, and 2, that the defendant has an ability to recoup its losses once competitors are driven from the market. The Supreme Court put these requirements in place because, quote, the mechanism by which a firm engages in predatory pricing, lowering prices, is the same mechanism by which a firm stimulates competition, because cutting prices in order to increase business often is the very essence of competition. And this is the important part for our purposes. It would be ironic indeed if standards for predatory pricing liability were so low that antitrust suits themselves became a tool for keeping prices high, close quote. And that is the precise risk we face if the Commission were to adopt a formal rejection of the Brook Group elements. The Supreme Court's Trinco decision merely confirms that a competitor has no duty to assist its rivals, and a monopolist only has to do so in unique situations. The decision was based on the real concerns that forcing competitors to assist one another lessens incentives to invest in your own business, turns courts into central planners who decide how businesses must deal with one another, and leads to what the Supreme Court called the supreme evil of antitrust, collusion. Rejecting Trinco could create a California standard under which businesses are compelled to assist their competitors as opposed to competing with them. Lastly, the Supreme Court's Amex decision lays down the rule that in two-sided markets, such as credit card networks, courts must evaluate the competitive effects on both sides of the transaction to determine whether the conduct on balance is anti-competitive. Rejecting this decision and adopting the staff memo suggestion that only one side of a dual-sided market should be considered ignores the fact that consumers are frequently on one side of dual-sided markets and oftentimes benefit from conduct that may harm businesses on the other side. Turning a blind eye to benefits that consumers obtain and focusing only on possible harm to competitors flips on its head the consumer welfare standard that has guided policy and courts for decades. There are critics of this decision. Of these decisions. There is no doubt about that. But these decisions reflect the modern economic thinking of how the antitrust law should be interpreted in order to protect consumers and competition. And expressly disavowing these decisions only undercuts the standards that courts have followed for years and will leave California courts with very little guidance on how to deal with these complex issues. With that, I thank you for your time and consideration, and if you have questions, I am happy to try to answer them.
Questions?
Thank you, Counselor. If you don't mind, I wanted to, thank you, Mr. Chair. I wanted to zoom in on the point you made about if one of your clients called you and, assuming we do something here and assuming that thing that we do is option 2, your client calls you and says, what's new and different? Like, how does this change?
Yep.
It seems to me like, and again, I'm keeping it simple, the major change that option 2, if we go that direction, makes is that now anything that's in 16720, the law can be violated by a single actor, whereas before we do whatever we do, it required collusion, 2 people. Why isn't that the simple answer? To point your client to the list of bad acts that formerly required collusion and more than one person, and now say, you can't do those by yourself anymore.
Sure. So unreasonable restraints of trade among more multi-parties, 2 competitors, for example, are very easy to spot because we know what they are. Price fixing, for example. 2 competitors cannot agree with one another on the price they're going to set or some measure of the price they'll set. A single firm, however, of course, has the ability to set its own prices, has an ability to do it itself. That is not a violation. So single firm conduct so if a single firm were to set its own price, could potentially be a violation of 16720, as you pointed out, because that's one of the things we think of. Bid rigging, market allocation, all those things that when you apply that conduct to multiple parties, it's very clear. But when you take away the multi-party conduct aspect, it's unclear what's covered by an unreasonable single firm restraint of trade.
So using the concept of unreasonableness, so I'm trying to put myself in the shoes of a judge who's sitting on one of these cases and using Amazon as an example. Amazon, as you said, is perfectly free to set its own prices. And so a new vendor comes to Amazon and says, hey, I want to sell on your platform. Amazon sees it. Amazon says, sure, we'd love to have you. The fee is $5 a month. It's the same amount we charge to everybody else.
Yep.
As a judge, there are other scenarios that would be red flags for me and signal unreasonableness. So for example, if certain types of vendors got different prices, if there were preferences for certain types of vendors or disadvantages, higher prices per month or per year, or however they do it for certain types of vendors, when they're selling essentially the same widgets as the other people who get the lower prices or the higher prices.
Right.
So like kind of borrowing from equal protection. Or if Amazon will only deal with a certain vendor for a particular type of widget for whatever reason, that's a potential red flag. Or if a vendor is locked into an exclusive contract, if you can only sell your widgets through our platform. So yes, there are business practices that wouldn't seem unreasonable, but there are some that would.
So first of all, I have to, let's remove Amazon from the
All right,
hypotheticals.
do you represent them?
It complicates things for a number of reasons, because of Amazon's obvious size. So there are things that competitors who have large market share are unable to do under current law that smaller competitors can do. Exclusive dealing, as you mentioned a minute ago. Smaller companies can decide who they want to deal with and set up exclusive distributorships. Other larger, let's call them monopolists, for example, may not be able to. That's the way that our law has dealt with it under Section 2 and Section 1, for that matter. So some of the stuff that you just described, choosing who you're going to allow to sell on your platform, or choosing what price they get, a lot of that today is perfectly lawful, as long as the party doing it is not a monopolist or does not have excessive market share or market power.
So couldn't that be incorporated into the judicial reasonableness analysis, that, you know, the size of the party that's doing the act matters? Your market share determines in part what is reasonable and what is not.
Absolutely. I think it does. And that is Section 2 of the Sherman Act, and the way that it's been interpreted by federal courts, which has said that if you don't have monopoly power or something close to it, Section 2 doesn't apply to you. So if you're a small business, Section 2 is not going to apply to you. If you have 70% market share in your market, Section 2 probably applies, and you need to make sure that what you're doing comports with that statute. So that's the way that we've dealt with the difference between big competitors and small competitors. And I think if we were going to address single firm conduct here in California, ideally, we do it based on the size of the people doing the things. That way, we ensure that small businesses in California are able to continue doing the common business practices, many of which we listed in our May submission, because they're not monopolists. They don't have excessive market share. And I think that's a view that this commission should adopt were to move forward with a single firm conduct statute.
So the concept that you just articulated from the Sherman Act context, that seems like the kind of thing to me that a judge could borrow from as persuasive federal authority in order to solve this problem. And I would personally be concerned if, you know, speaking of the latter half of what you said, I can project out problems with both initial arbitrariness of whatever market share percentage or amount of asset, whatever market capitalization, whatever figure we go with, initially we're going to have an arbitrariness problem. And then going forward, value of money changes, markets change, sizes of, you know, like things change. And I wouldn't want to put the legislature in a position of having to play catch up, and then that arbitrariness problem repeats itself every time. So I would think that you would be arguing for a broad standard here that you can then let the courts work out, and you can make evidentiary arguments about size of markets changing and things like that.
Well, sure. And I think you'd have that ability to do in any case. Again, I think what you're referring to is a monopolization standard. And as long as we at least allow courts to borrow from the 130 years of federal law on what's a monopoly and what's not, that's helpful. I don't know that that informs what an unreasonable single firm restraint of trade is. And that to me is different from monopolization. Monopolization is pretty clear. And so the second section of option 2, which basically endorses section 2 of the Sherman Act, I mean, that you can kind of get your head around, right? For all the reasons you just mentioned. It's the earlier part that talks about restraints of trade and freedom of production and the others that are just unclear.
Because they're being done by a single actor.
Correct.
Okay, thank you.
Other questions from commissioners? Am I understanding what you're saying, that the only actions that could be unlawful under antitrust law by a single firm would be actions undertaken by a monopoly?
For the most part, under federal law, single firm conduct is governed by Section 2 of the Sherman Act. Section 2, one of the elements of a Section 2 claim is the possession of monopoly power. So yes.
And does that then imply we don't need a single firm law because federal law already does it? And if you want to do anything, just copy federal law.
We are firmly of that view. And that gets back to my first point, which is the issue of need. Do we need our own single firm conduct law? As I've said before, a few times we've talked, the California Attorney General has been incredibly successful at using Section 2 in its lawsuits in federal court. Private plaintiffs in California have been successful in using Section 2. It is a well-used statute in federal court for California issues and state issues in other states. So yeah, we are of the view that we don't need a single firm conduct law, at least based on the current analysis. And one of the reasons is because Section 2 is there. We do have 130 years of precedent interpreting it, so businesses know what's in and what's out. And we feel like the status quo is the right thing. But to get back to my earlier point, let's study it. Let's do an actual analysis, empirical analysis of what's happening in California. And are we being injured because we don't have a single firm conduct law? We could do that analysis and go from there. Otherwise, I feel like we're putting the cart before the horse.
The cart right before the horse. Got it. Okay. The other thing, sorry about that. The other thing was in the last part of your opening presentation, you talked, I think it was the Amex case, where it sounded like the trade-off between harm to competitors and benefit to consumers. And my general understanding is the underlying purpose of antitrust law in the first place is to protect a free, open, competitive economy. That's why we do this in the first place. And so it having benefit to consumers nullify the negative impact that businesses are taking against their competitors bothers me.
So it's a good question, and we're not suggesting that at all. First of all, to your first point about what the antitrust laws are intended to do, yeah, to have open and free competition in the marketplace. The way we judge that generally is the consumer welfare standard. Are consumers better off? Are they getting innovative products and services at low prices? That's sort of the way that we have thought about evaluating business conduct. How does it impact consumers? On the Amex case, I'm not suggesting that you can harm competition and it's fine as long as consumers benefit from it. I'm not suggesting that at all. What the Amex case says is that if you're going to evaluate a dual-sided market like a credit card network, you got to look at both. So not just harm to competitors or merchants, but also benefits to consumers. And you as a court and as a jury, you need to look at both of those things. What's suggested in the staff memo is reject Amex and state that you only have to look at one side of the dual-sided market. And we think that's wrong. We think it makes sense, given the consumer welfare standard, to look at both. And one might outweigh the other, but that's why we have judges and juries.
Okay, thank you. Victor.
With regard to the concept that there's a lot of uncertainty created by this, is that destined to be the case because it's a new law? And so it's short-term uncertainty. Over the body of 5-10 years, you're going to get a body of case law that's going to tell you what is an unreasonable restraint of trade. It's just almost definitional that if you have a new statute, you're going to have to develop the case law. So I'm not so perturbed by that your clients have absolute certainty. Now, your clients may want absolute certainty, but you as a law firm will make a lot of money and have a lot of business in guiding people on what is unreasonable restraint of trade and helping them, foresee problems with their behavior and guiding them accordingly. I mean, it seems to be a good thing to me that there will be short-term uncertainty for the purposes of building a long-term body of case law that will help California address an area, single firm conduct involving individual actors, that is not being adequately addressed by the feds in the state's opinion.
And I've thought about this a lot, Commissioner King, and I think you're probably right. Anytime you pass a new law, there's going to be some uncertainty. And I've been trying to think of situations where that wasn't the case, but it depends on how you do it. And so if you are to adopt a new California statute, for example, but reject all federal law that has looked at these issues for 130 years, and say we don't want to listen to that, we're going to build our own law. I'm not sure it takes 5 to 10 years. It may take longer than that because it's got to get itself up to the California Supreme Court before you get any certainty on what the law means. That takes time, as you know, and you need multiple cases. And all the while, we have uncertainty on the business side, no question. We've got a lot of new litigation. And as I'm sure this commission knows, antitrust litigation is expensive and takes a long time. And so if it's just, well, we're floating around until we all figure it out, there's a lot of short-term pain there. And that short-term pain equates into, at least the studies we have seen from economists to this commission, lost jobs, lost sales, lost tax revenue. And that's just got to be part of the equation in my view. We've got to consider that.
Okay, an unrelated question. From what my reading of the comments of the Cal Chamber summarized by staff, although we understand you prefer that there be no laws, new laws, and you'd prefer option one over option.
I think you're misstating our position.
Okay.
We've never said we don't prefer there's laws or new laws. We've never said that.
Well, let's put it this way. Out of everything that's on the table,
Yeah.
staff has seemed to summarize that you're most comfortable if the commission were to move forward with option two, with qualifiers on the phrase restraint of trade, incorporating the concept of reasonableness, and with the comments specifically suggested by staff at the end of its analysis of option two, again, referring to the reasonableness of the restraints of trade. The staff summary said that that's the option Cal Chamber, if it had to, would most find acceptable. Is that accurate?
I don't remember reading that, so I don't want to put words in anyone's mouth. That's not our position. We have not endorsed option two. We haven't endorsed any options. The main reason is the most important question has never been answered, which is, do we need new laws? Do we need to revise laws? And if so, what are we aiming at? What are the problems right now? Is it monopolization? Is it this amorphous single firm restraint of trades? What's the problem we're aiming at? Until we know that, I can't give you an opinion on options. Option two has problems because of the restraint of trade language, because of the other language that I identified earlier. All of the options have problems if we're kicking out all federal law, or at least telling our judges they don't have to think about it, or it's not important. So we haven't endorsed any of the options.
Yeah, we're not untethering.
Yeah.
And untethering was not my word.
No one is pretending the supremacy clause doesn't exist, okay?
Understood. So I don't think we've, Commissioner King, we haven't endorsed any of the options. We'd like to see the hard work done first, which is what's the problem and what are we aiming at? In terms of phraseology, in terms of, what a statute would look like. Yeah, I think doing something similar to Section 2 is probably the safest because most businesses know what a Section 2 violation is. And when there's gray areas, you've got a lot of lawyers who can think about it and argue it from both sides.
All right, thank you.
Thank you. Any
Thank
other
you.
questions? And I would like to welcome back Assemblymember Pacheco.
Thank you.
So I see no other, next would be next speaker.
Next speaker can step up.
All right, Dan.
Dan Robbins.
Great. Thank you. Nice to see everybody again. I can't resist the opportunity to say there are some antitrust proposals that are very narrowly focused and won't engender 10 years of litigation. Big plug for SB 25, passed in Washington, passed in Colorado.
Passed the Senate here, right?
Yeah, 36-1, thanks to Senator Blake Spear, and passed Assembly Judish earlier this week. It's obviously much more focused, but not all laws, require a lot of litigation. So, one of the reasons we're here is because California doesn't have a single firm law. Same in New York. That's why there was an effort to make changes there. So by definition, we don't have any state precedent on this issue because nothing for judges to rule on. In contrast, we have 135 years of precedent at the federal level since Senator John Sherman's act was passed in 1890, and thousands of federal judges. Maybe some of the opinions were incorrect, but a lot of smart people working at this for a long time, developed a lot of case law that we rely on. So, one of the things we contemplate in the memo is, well, we don't really need this relevant market piece, but that's been a bedrock of analysis for many, many decades. And in the unanimous decision out of the liberal Warren Court, the court said, without a definition of relevant market, there is no way to measure the defendant's ability to lessen or destroy competition. So I suggest to you, if that's something we need to know what market we're talking about. If Dan's hardware store in some small town sells hammers, is it just the physical sale of hammers, or do we include hammers you can get online or from some other source? It's pretty critical to understanding, what the market looks like and the ability of my hardware store to engage in anti-competitive conduct. And then, oh, sorry, wait, I'll be right back. Sorry, I had another quote for you. We have a ton of great stuff that we've seen over the years. Thurgood Marshall, very famous Supreme Court justice, had this to say: antitrust laws in general, and the Sherman Act in particular, are the Magna Carta of free enterprise. They're as important to the preservation of economic freedom and our free enterprise system as the Bill of Rights is to the protection of our personal freedoms. You have a lot of great statements, a lot of great stuff out of the past. I think it'd be a mistake just to, I don't know what the right word is, untether, discard, diminish, pick your word. But it's at least it's clear to me from reading the memo that federal stuff, they made some mistakes. And so we need to step away from the errors of all these people. I just think that's going to cause a lot of unpredictability. And I don't disfavor Eric making a lot of money. He deserves it. But as somebody who's a compliance officer within a global trade association who has to advise on what can be done in countries, 100 different countries have antitrust laws. So I have to give advice about, what can you do, what can't you do? I hate for my state to be the least predictable of those 100 because we're starting over again, completely fresh. I always try to make, I'm the sponsor of SB 25. I'm trying to make changes myself and with the Uniform Law Commission. So I did suggest that maybe the thing to do is to adopt the Sherman Act into our law and then identify the cases we think are erroneously decided. This is not unprecedented. We did this with Illinois Brick that Cheryl mentioned earlier. The Supreme Court ruled indirect purchasers can't sue. We thought that was wrong. So in 1978, 1979, the legislature passed an amendment to the Cartwright Act that said, we take a different view. So if you're suing under California law and you're an indirect purchaser, go for it. That federal Supreme Court decision we think is wrong. So if we think, Brook Group or Amex or Trinco or some other case is wrong, then let's do it the same way we successfully did it. Going to Commissioner King's point, let's try to look at enactability too. We successfully did it before. If we take this basic framework, we keep a lot of this analysis like relevant market and market share and some conduct guidance, and then just articulate what it is we think was incorrect. And say you can't do these things in our state. That would be, my view, that'd be a lot clearer. And also, I think it helps keep businesses here. We have to compete too. Our state has to compete with Texas and Florida. In my own sector, a lot of filming goes to Georgia. A lot of filming goes to Canada and the UK. We want to keep it here. And we're very excited the governor's committed to helping us do that. But we have to recognize that unpredictability is a big minus. You want to go to places where you understand what the law is and you can invest there and get something done. So just a couple of other things. And all this really goes to these findings and declarations. My view is if we want rules, let's just put it in the black letter. Let's not, leave it to something more amorphous. We've rejected, or at least I believe you've rejected, this abuse of dominance test from New York. But then, we've got this New York prefatory language creeping back in. And that bill died again earlier this month in New York, 5 straight years in a fellow blue state that's a lot like ours. It always passes the Senate because the author is the deputy Senate leader. And you might remember him. I invited him to come speak to you because I think he's a very thoughtful and good legislator. But it always fails in the Assembly. Where does it usually fail? It fails in the Economic Development Committee because it's not going to help develop the economy of the state of New York. That's why it never gets out of that committee. And so just something to think about. Like I wouldn't, obviously it's your decision, but taking stuff from a bill that's failed now 5 times in a row and has massive opposition in New York, it's not something I would recommend. Also, we seem to, we like the 2023 M&A guidelines. These were guidelines done in the last administration. They've been endorsed by the Trump administration. So take that for what it's worth. They're a rejection of the Obama 2010 guidelines. And I keep on saying guidelines because that's what they are. These are guidelines that the federal agencies put out to give business information about what they might use to challenge. It's not appropriate in legislation. There was legislation earlier this year in Connecticut that took those guidelines and said, this is the law in Connecticut, another fellow blue state. It didn't get anywhere. It didn't get out of its first committee. It immediately got changed actually to just like restating the Clayton Act. And then there's so much bad blood from that didn't go anywhere either. So nothing got done. So I just suggest a word of caution. If you're going to pull those are controversial, even though they've been, endorsed by the far left and far right. Just be aware of that. And then just the last thing, the preemption point, I raised it in the MPA letter, the Copyright Alliance, which represents all copyright sectors from single songwriters to big companies that make video games and others. They raised it as well. There's nothing in the text right now that denigrates copyright or treats patents unfavorably. But the way this works is that those are federally granted exclusive rights. Sometimes courts actually call them monopolies mistakenly. And so there's a bundle of rights that are given. And so if I make a movie, I can give an exclusive license to Commissioner Simpson. And guess what? That means nobody else can be the licensee. You're excluded from that market. And so what tends to happen is, cases and issues arise from that. At the federal level, for a while, there was a presumption that the mere possession of any copyright gave you market power, even if it was just, a single song or a grade B movie or something like that. That got reversed by the Supreme Court in 2006. But it just, I mention it because there's an easy path for things to go sideways along there. We've seen it in the case that Cheryl mentioned, Orson v. Miramax. This was Pennsylvania's misguided attempt to limit a theatrical motion picture run to 42 days. So after 42 days, you had to give it to anybody who asked for it. Clear, violation of the Copyright Act coming out of Section 301. So those are my comments. Glad to answer any questions. I'll repeat again. I'm trying to focus on predictability because businesses need that, or they desire it and they'll go places where they can find it. So we need to be sensitive to that. And it's for due process purposes. If something's going to be illegal, we ought to pretty much tell folks what it is so they can avoid that. And so I can tell them, or at least I can hire Eric and pay him a lot of money to tell that, which I don't object to. And also, my other constructive suggestion is let's take, Sherman Section 2, and then let's do what we did with Illinois Brick and identify these cases we think are wrongly decided and say, you can't do that here. And I think that's a much more predictable, focused way. I know that's not among the 3 options on the menu. It's just sort of, I don't know where to put it in that framework. But any of it, those are my thoughts. Thank you. I appreciate you listening and glad to answer any questions.
Any questions or comments? David?
Thank you, Mr. Chair. Thank you for your thoughtful comments. The one point that I wanted to make is that I'm a little surprised that you're not making a different argument, which is telling us don't name any specific cases. Leave it as just a general presumption, which is declaratory of existing law, that federal law in this area is only persuasive, not compelling authority. Leave it that way, I would think you'd be saying, so that you can have a second bite at the apple when you go litigate this. And then for each of those individual cases, you have a chance to either bring them in or eject them from California law, whatever your preference might be, rather than having us codify it. So why am I wrong? Why is a general standard not better for you?
So, I'm looking for certainty. In my day job, I'm the compliance counsel. So I have to tell people, and telling them, putting in gradations of litigation, which is usually expensive, is not popular. And I just think, so what we're going to see in the way it's currently structured is, so these cases would normally go to federal court, as Cheryl said. You have the federal claim and the state claims there, and maybe the courts would get confused about the standards. But what's going to happen now is the case is going to go first to state court, to a state court judge who, for the reasons I articulated earlier, has zero experience in this. And so it's going to enhance the unpredictability. And, my thought is I don't want to, I don't want to do something and have 50 different arguments about why I shouldn't be convicted for doing it. I'd rather know what, I know I can't fix prices. I can't divide markets. I can't rig bids. And, there's a long list of things. And it helps me because I can tell, all the folks in my sector don't do any of these things. But I think going into state court and having to do this all over again, that's at least, I don't know, it's going to take a long time, as Eric mentioned.
I get it. I get the concern. I get the multiplicity of venues that you'll have to make this argument in. The reason that that's not ultimately persuasive, I think, is because we live in the country we live in. We live in a federalist structure. There are 50 different states plus the federal government. So that means you get 51 different sources of law. And the ultimate end of the argument you're making, I think, destroys that federalist system. And it's ultimately an argument for we should just have federal law for everything. At the very least, we should just have federal law exclusively for antitrust so that we only have to file in one venue. And we only have to worry about one source of law. That's where that goes. And that somewhere in the comments, there was a point about, going there, or arguments that go there rob California of its power as a sovereign state to define its own law for its citizens. Thoughts?
Yeah, we did that with Illinois Brick and it's been fine. I think there, it's because that's something we all understand. Are you an indirect purchaser? No federal suit, but yeah, you can sue here. I think there are differences among the states. There's probably more commonality than there are differences. I think, frankly, if the New York bill passed and we had something that was different, but yet pretty far off, you might get a move to preempt the state law. This is, I have to admit I'm biased. Since I'm the past president of the Uniform Law Commission, it's like the UCC is the same in all 50 states. The Uniform Trade Secrets Act is the same. That's what we do, try to look for places where that's important. So, I think, using the approach I articulated, we've got the freedom to make those choices if we want.
Yeah, I think you're right that ultimately the law moves towards consensus, and California courts, the first thing they're going to do is look and see what else is out there. So they're going to look at what the other states have done. They're going to look at what the feds do, especially on the single firm conduct issue, if we wind up going that direction. So even I'm overstating it and saying that you have to deal with 51 different sources of law. Technically, that's true, but they largely look the same in many important aspects. So I think you'll be fine.
Yes, I hope so. Let me see if I didn't have any other thoughts. Any other questions?
Questions from commissioners? Seeing none?
Very good. Thank you.
Thank you. Next presenter?
Yeah, can somebody please step up?
Gladly. Good afternoon, commissioners. My name is Ben O'Brien. I'm here on behalf of California Life Sciences. California Life Sciences represents over 1,300 organizations in the life sciences community. This includes pharmaceutical, biotechnology, medical technology, academic research institutions, all committed to advancing innovation and improving health outcomes across California. Our mission is to facilitate a favorable environment for life sciences to flourish in California and to continue to lead the nation in delivering innovative solutions to address pressing patient needs. CLS members forge an outsized impact through clinical trials, breakthrough medicines and treatments, while directly employing over 350,000 Californians. So it's for those reasons that CLS wishes to share our concerns regarding the Commission's proposed single firm conduct provisions. So we recognize the growing interest and concern around consolidation in several sectors. However, we believe a California-specific single firm conduct provision that diverges from precedent or introduces unnecessary legal uncertainty could severely impact California's world-class life sciences ecosystem. Specifically, we're concerned with the proposal's potential rejection of federal precedent relating to relevant market and market threshold. So I believe Dan was touching on this a little bit. We really believe that including those definitions around market power and market size are critical for our sector, as many of the companies are small companies, and as they develop and create a new drug or a device, they might be seen as a monopolist, even though they're entering this new market. So I guess imagine a California-based biotech company which has developed a first-in-class biologic treatment for a rare disorder, rejecting certain precedents around market size and market threshold, and narrowly defining that or rigidly defining that in California, applying a standard that's lower than the federal threshold, could label this particular biotechnology company as a monopolist simply for this innovation and being first to market. Additionally, we have some concerns over the vague nature of option 2. Specifically, we feel that this option doesn't give courts enough guidance in how to distinguish restraints of trade that promote competition from those that suppress or destroy competition. I believe this was also mentioned by Eric. We're a little concerned with the language underneath that initial restraint of trade section, where it dives into concepts like attempts to restrain free competition, attempts to restrain free trade or free production. We don't, I guess, we look for more guidance on what those attempts are and what would define what an attempt under that kind of section. I guess, as we've noted, and Dan and Eric have also noted, uncertainty can be detrimental to all businesses, specifically in the life sciences. We have a dynamic and complex kind of ecosystem between academic research institutions that often drive these basic science innovations, federal institutions that provide grant funding, startup companies, large companies, and venture capital that all have to exist in one ecosystem in order to get things across the finish line. I'll note, especially in our sector, it's extremely difficult and rare to get a drug all the way to the end. And that often involves many different parts of this ecosystem working together in collaboration in order to get that across the line. So protecting some of the business practices that are used in the sector in order to get those things to where they need to be and then into patients is a critical thing that we'd like you to consider as you're developing these proposals. Particularly a lack of clarity, we feel, over single firm conduct could reduce pro-competitive conduct and misinterpret practices like exclusive licensing used in our sector, often in not an anti-competitive way, as the only way to develop treatments for novel diseases or rare conditions that often don't get investment because big companies realize that they won't be profitable or won't be profitable until they're brought into the market, and there's a lot of risk involved in getting that into the market. And so often rare diseases don't get a lot of investment as a result of that. I guess overall, we feel California's antitrust regulatory environment has previously encouraged life science companies to invest here, and that's kind of what's driven and allowed the state to recognize the value of the high quality research, jobs, and tax revenue that's generated through our sector. And so this has kept California the epicenter of the life sciences industry, birthing and sustaining thousands of companies, employing millions of Californians, and creating products that save lives throughout the country and the world. Upending the current standard for acceptable single firm conduct in the state would inject considerable risk and uncertainty into that ecosystem. We appreciate the opportunity to share these comments, and I know as the proposals become more specific, we're happy to share more specific feedback from our members around those. So thank you for the time. And
Thank you.
I'll answer questions, but I'm
Questions or
not
comments
a legal counsel, so.
from commissioners? Hearing none, seeing none. Thank you.
Yeah, thank you.
And last presenter in the room, last but not least.
I don't know about that. My name is Robert Singleton. I'm the Senior Director of Policy and Public Affairs at Chamber of Progress. We are a center-left tech industry association supporting inclusive innovation. I'll keep my comments exceedingly brief since we submit written comments that go into much more detail, and we've done so at multiple occasions that are much more tailored to the specifics of some of the findings of the working groups. So I'll just summarize kind of our general overarching response, in particular to the two memos here. We share the Commission's goals of protecting consumers and promoting fair competition, but rather than adding layers of new law, California should invest in better enforcement capacity under existing frameworks. The Cartwright Act and federal antitrust laws already offer robust tools. To the extent anything is lacking, it is resourcing, not statutory reach. So we welcome continued dialogue with the Commission. And again, I would refer to our written comments we previously submitted. Thank you.
Okay. Questions or comments from commissioners? Seeing none, thank you. Folks, online?
And if anybody else who is online would like to speak, please raise your hand. Looks like we have two now.
Start, Mona Masri, please.
Hello, yes. My name is Mona Masri, and I'm calling in today from representing Economic Security California. We too have provided previous written comments, but I want to first thank the staff for their incredibly thorough and thoughtful work on this study and for continuing to create opportunities for meaningful public input. So regarding the single firm conduct provision, we recommend the Commission adopt option 2 without changes for two primary reasons. One, it reinforces the principle that the Cartwright Act is both broader in scope and more comprehensive than the Sherman Act, providing stronger enforcement mechanisms than federal law. And second, by maintaining clear separation between California antitrust law and the acknowledged deficiencies of the federal Sherman Act, it creates predictability predictable, well-established rules for market participants based on existing legal frameworks, thereby avoiding the risks and uncertainty inherent in implementing an untested antitrust approach. And we also recommend that the Commission adopt the 3 essential provisions: the enhanced purpose statement, the statement rejecting federal principles, and the statement rejecting federal precedents. So these provisions, grounded in current law, will provide courts with clear guidance on the Cartwright Act cases and ensure California's antitrust law remains independent from the federal precedents that have weakened antitrust enforcement. The enhanced purpose statement appropriately catalogs the broad scope of harms that result from anti-competitive conduct, including harms to workers, consumers, and small businesses. And the statements rejecting federal principles and precedents are all grounded in and inspired by the comments in the expert white papers previously shared with you, and are particularly important given the problematic evolution of federal antitrust law over recent decades. By explicitly rejecting the false positives framework and the presumption that vertical arrangements and unilateral conduct are unlikely to harm competition, the Commission can prevent these flawed principles from being incorporated into California law and eventually eroding California's ability to protect competition effectively and independently for the benefit of its own residents, consumers, workers, and businesses. So we encourage the Commission to approve and move to close on the policies it has already reviewed and endorsed, specifically option 2 and the enhanced purpose statement. So we thank you again, both the commissioners and the Commission staff, for their excellent work on this really important issue, and look forward to seeing any additional recommendations from the Commission as this process continues. Thank you.
Thank you. Questions or comments from commissioners? Seeing none, hearing none. Thank you. And the next presenter?
Gil Lara.
Good afternoon, Commissioners. My name is Gilbert Lara on behalf of Biocom California. We're the largest life sciences organization in the world committed to advancing innovation and improving health outcomes in California. Biocom California shares the concerns regarding the proposed single firm conduct provisions. We've seen no evidence that California's antitrust laws are failing to protect businesses or consumers, nor has anyone measured the costs these proposals would impose on our economy. California's life sciences industry generates over $414 billion in annual economic output and supports 1.24 million jobs. This success depends on complex collaborations between large and small companies, where larger firms provide funding and resources, while smaller biotechs drive innovation. The proposed provisions threaten these vital partnerships. We're particularly concerned about rejecting federal precedent on market definitions and thresholds. This could label innovative companies as monopolists simply for being first to market with breakthrough treatments for rare diseases. The untethering text would remove decades of legal guardrails, making it impossible to distinguish aggressive competition from anti-competitive conduct. The proposal could restrict common business practices like licensing agreements and exclusive dealing arrangements. For our industry, exclusive licensing of intellectual property is essential. Life sciences companies invest billions in product candidates, potential treatments seeking regulatory approval. These candidates may or may not succeed, yet companies must secure exclusive rights to justify the investment and risk. Without exclusive licensing, companies cannot recoup development costs, and the hope these promising therapies represent for patients will never become reality. This strikes at the core of how medical innovation works. The uncertainty alone would hinder innovation. Companies would hesitate to invest in California, slowing the development of new therapies and ultimately harming patients who depend on our innovations. Before proceeding, we urge the Commission to conduct thorough economic studies to determine if the new laws are indeed what they would cost. Thank you very much for your considerations and have a great day. Thanks.
Thank you. Any questions or comments for Mr. Lara? None? Seeing none? Thank you. Any other, one more presenter?
Rhiannon Morales.
Good afternoon, Commissioners. My name is Rhiannon Morales, Legislative Aide of UFCW Western States Council, representing over 200,000 workers who are principally employed in the grocery, pharmacy, food processing and healthcare, cannabis, and merchandise industries. part of the 1.2 million member UFCW International Union. First, a word of praise for your staff who continue to do a superb job gathering diverse experts and offering you thoughtful and well-supported options. I would like to make 4 quick points about the proposals. First, we continue to be pleased to see staff include in their proposals an express focus on monopoly power and the harm to workers that come from a lack of competition among employers. Second, we continue to applaud the staff's recognition of the broad-based consensus among your diverse experts that existing antitrust laws have failed consumers and workers, and that reform is urgently needed. Third, regarding single firm conduct, we reiterate our support for option 2, reiterate our support for the draft findings and intent and enhanced purpose statement to be included in the legislative text. Each and every one of them are absolutely necessary for option 2 to work. We also endorse staff's proposed improvements to these items as reflected in June 17th memo. Fourth, echoing a broad coalition's request back in December, we respectfully urge the Commission to formally make an interim endorsement of option 2, including the draft findings and intent and enhanced purpose statement no later than at your September meeting. As was highlighted for the Commission by that broadly supported letter, interim recommendations are amply precedented. Respectfully, you and your staff have done excellent work, and it is now time for the legislature to hear from you. Thus, if the Commission is satisfied with option 2, the findings and the purpose statement, we are, along with a diverse group of supporters, we respectfully request you approve those and continue to deliberate on the remaining issues such as misuse of market power and mergers, which we ourselves are still reviewing. Thank you for your time.
Thank you. Any questions or comments from commissioners? Seeing none, hearing none. Thank you for your comments. Okay.
Any more?
Any more? All right. So I think at this point, staff was going to walk through the decision points, the
Yes,
potential decision points.
and just to emphasize that the commission doesn't have to make decisions if there's things that you want more analysis on. That's fine. If you would like to make a decision on something, I think we should take a roll call vote so it's clear. But if it's, we like where you're headed, but we need more, that could be just as direction to staff.
Okay.
So that said, I'm gonna try to turn to all my bold highlights. Let's turn to the basic single firm conduct provision. It appears on page 5. And the question for the commission, and of course, if anybody has any more questions, please let us know. But the question before the commission is, would the commission like the staff to make revisions or conduct further analysis of option 1, despite not having received comments expressly in support? And although we don't say it in here, if the commission desires, they could more expressly direct staff to stop work on it.
Comments from commissioners? Kara?
I have one. So I know that we discussed this, how the language is taken from the federal act, and that seemed to be the primary concern. Is there a way to take the concept of it, but not adopt the same language and have it be sort of the, retain what the whole primary, gist of it is without, if we don't use the same language, maybe there would be enough difference so that there wouldn't be a rush to assume that it's supposed to mirror the federal law.
Doesn't that create the unclarity that we're trying to
Well,
avoid?
I'm just,
And to some,
just throwing it out there.
Yeah.
I think maybe Sharon can,
Needs to have their mics on, please.
yeah, Sharon can correct me. To some degree, I think option 2 does that because it takes the language from option 1, and it's one of the two descriptions of unlawful conduct. One is restraint of trade or attempt to exercise competition. 2 is the language from option 1. So to some degree, and anyway, did I get that right?
Yes, and Cheryl?
Yeah, and I think the closer we can stay to, the closer we stay to well-known antitrust terms, I think it reduces arguments that it's going to cause massive confusion. And if the courts are confused, they're just going to go look at federal law. So we want to avoid that result.
Yeah, it seems like we have a couple of dilemmas. If we just make up completely new terms, no one knows what they mean.
Right.
And they have to start on a blank slate, which is bad. Or if we borrow terms, those have understood meanings.
Right.
And the courts will just look at those. Between the two of those, I'm more inclined to option 2 because it at least it says it basically says go ahead and borrow from federal law as appropriate and as persuasive, rather than just making it up.
Yeah, I mean, I wasn't suggesting we, not use any terms of art or things that are recognized within the industry. I guess it's just more if the main concern was that it was mirroring federal law, that if there was a way to solve that, then that might assist with, trying to come up with a California standard that still retains some of the federal, some of the stuff that we want to retain when.
Well, from a drafting perspective, like which do you think is more, I don't know, elegant is a better way to put it? Like
I think we'd need to.
New terms or existing terms?
We would need to look into it. I wouldn't want to try and speculate at this point, but just curious. I was just curious. It seemed like this option 1 was intended to mirror the federal law, and that was the main reason why we were opposed to it. And so if there was a way to sort of massage it, to sort of retain some of it, but also put a California spin on it, maybe that would resolve some of the issues, recognizing that we're also advising the courts that they aren't bound to the federal case law.
Victor.
Another way of putting what you said is you're looking for
Option
like
two. Is that what you're
perhaps a 1.25 option. Because you're trying to move a smidgen off of 1, but not get as far as 2. I mean,
Yeah,
if I could try to capsulize what you're trying to do
I think-
here. I mean, I think we have to fish or cut bait. I very much like Commissioner Carril's earlier motion to just abandon 1 and 3 altogether. We've had lots of discussion. There seems to be a lot of support for option 2. There's no support for option 3. There's modest support for an option 1, with everyone who supports option 1 really wanting it to mirror the federal statute and nothing else. Right. I mean, let's the attempt to turn 1 into 1.25 is kind of a mission that's doomed to fail, because the whole point of option 1 is to stay federal and to be 1.
Yeah.
So you can't be 1 and be 1.25.
Yeah.
So I think from what I've heard, we've heard a number of people support option 2. Staff is supporting option 2. I'm very pleased that staff added language regarding unreasonableness, the reasonableness of restraints of trade to option 2 to sort of turn 2 into 1.75. So I'm, again, more comfortable if anyone wants to just cut to the chase and make the motion to abandon work on 1 and 3 and not endorse a particular version of option 2 for now, but just to ask that option 2 continue being worked. Particularly with regard to these declarations, which there seems to be a lot of uncertainty about. And we haven't heard a ton of public opinion about the declarations. We got a lot of written opinion about the option, but not about the declarations. So 2 needs to be worked and cooked. But it seems to me 1 and 3 could just be sort of abandoned at this point, if I could be so bold to say that.
Mr. Chair,
Yes.
I'm prepared to make that motion, but before I do, I want to make sure I gave Commissioner B and Commissioner Kubas a chance to weigh in.
Right. And Commissioner Pacheco and.
Right.
Other commissioners want to express their views? I mean, I think the potential motion that might be forthcoming is to expressly reject options 1 and 3 and then work on option 2.
That's my plan. But if Anna or Commissioner B want to weigh in, or Commissioner Pacheco, I'm happy to hear from him.
Any other commissioners want to weigh in on that idea?
I'm comfortable with getting rid of option 3. I kind of like the idea of looking at 1 a little bit further, taking into account Commissioner Carroll's comments.
And from my perspective, I'm ready to vote on option 2 and reject 1 and 3.
Okay.
And at this moment, this is Assemblymember Pacheco. I'm
Mhm.
comfortable with getting rid of option 3 and still keeping option 1 and 2.
Okay.
So, Mr. Chair, with the comments of my colleagues in mind, I will move that we move forward with option 2 and direct staff in further revisions of option 2 to incorporate the thoughts that my colleagues have expressed about trying to incorporate some of the language from option 1.
I believe it's all in there.
Yeah. I'm not sure that we have, I think we have consensus on the core idea of option 2. I don't think we have consensus on the language of it. But I think from a process perspective, it's easier for the staff to move forward with a single proposal, the language of which we will go through 1 or 2 drafting rounds. And I'm sure staff can even present us with a couple of different sub options within option 2, a more aggressive one, a less aggressive one that's more expressly tied to federal law, one that's expressly not tied to federal law, something like that. So that would be my motion.
Okay. Thoughts on that from commissioners? Staff, any?
It sounded like a motion. We're happy to do whatever the commission directs
Do
us
we need a motion?
to do.
Not for, yeah, for directing staff, we don't need, we don't need a motion.
Then forget it. I was
So,
being,
so what you'd like us to do, I hear, although it seems like there might be some support for just saying stop with option 3, but we can talk about that when we get there. But
I haven't heard anybody express support for option 3 on the commission.
Other than our blue ribbon committee.
so
Out of the commissioners.
just to recap, what I'm hearing is you're directing staff to continue to work on option 2 and take into consideration the thoughts behind option 1 when looking at it and presenting additional language to the commission. Is that fair?
Yeah, and I don't want to speak for my colleagues, but what I'm gathering from Commissioner B and Commissioner Jenkins and Commissioner Kubas is I think we're going to need to do some more drafting around this question of the extent to which, like the core choice we have to make is whether we're going to directly borrow federal terms and what kind of direction we give associated with that, or if we don't borrow federal terms, and then what kind of direction we give in that context. So we still have some choices to make on option 2, but for moving the ball down the field, I think that's the best direction to go.
And if I recall, the one specific change, it sounds like there was, we didn't vote, but generally consensus that restraint of trade ought to be unreasonable restraint of trade, right?
That was my preference.
Yeah.
I like that.
Yeah. But I had same.
Both in the statute and in possibly a comment, a declaration.
Right.
And are we going to also try and attempt to define to address some of the concerns about the concepts of attempting to restrain the free exercise of competition or the freedom of trade or production? are we going to try and further define those? Or is it sounds like that's sort of an up in the air, those are up in the air concepts that might be difficult to enforce.
My understanding, maybe I misunderstood Cheryl, but those are terms that are elsewhere in jurisprudence.
Oh, I thought
In the Cartwright Act.
The Cartwright
Yes.
Act.
And restraint of trade is also in the Cartwright Act.
that one I was aware of, but I thought that one of our speakers mentioned that they were new concepts that
Concepts for single firm, perhaps.
for single firm, I see.
Oh.
And is that something that needs to be more clearly stated as to single firms?
I don't think they've been much used for multiple conduct or single conduct, but they were put in the statute in 1907. They've been there a long time.
Could we just get more background on what they mean?
Okay, that'd be helpful.
Yes,
That'd be helpful.
no problem.
You probably have the ledge history from 1907 laying around in your office. Just go look it up, Kara.
This is when I'm very grateful that the meetings are recorded,
Yes.
because I will go back and watch this at least 2 or 3 times to make sure
1907, yeah.
we're doing everything you directed us to do.
All right.
Okay,
Um,
so
So do we want to just toss option 3 overboard?
sure.
Any, is there do we need a motion to do that?
Yes, if we're
Okay.
gonna stop it, I think
Okay.
it would be
All
good
right.
to be clear.
Is there a motion to pitch option 3 out the window?
Well, I wouldn't put it like that.
Oh, I'm sorry.
Let's not move forward with
Let's
that.
not,
with that
to not
one.
move forward on option 3. Is it
And untether ourselves from it.
untether ourselves from option 3? Is there a motion?
I so moved.
All right, it's been moved
Second.
and seconded.
Okay, I will call the roll. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner Jenkins,
Aye.
Assemblymember Pacheco,
Hi.
Commissioner King,
Aye.
and Commissioner Simpson.
Aye. Okay,
Okay.
next decision point, or points.
Next decision points. So now we're moving on to findings and declarations. So
Starts on page 13.
yeah, and so turning to, we have a lot of general
Starts on
public comment. So
15.
page 15 is where we're actually putting the question to the commission. So the general question, but we're going to go through them one by one, is we're asking you to consider to adopt one or more of the options on relating to legislative findings and declarations / codified intent language with or without changes. So the first one is the basic purpose statement. What's the feeling on that one?
It's a direct quote from a California Supreme Court case, right? So it's cited there in footnote 47. So I'm all aboard for moving forward for its adoption as written.
I have a slightly a variation on that suggestion if you want. I would prefer to put this in the code, in the Business Professions Code, which is where the Cartwright Act is. I would probably put it in the introductory article, which is the stuff. And rather than saying the legislature finds and declares, I would suggest saying the purpose of this chapter is the promotion and protection of free and fair competition that is fundamental to the blah, 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 blah. So it's more than just an expression of somebody's opinion, that is what the statute says its purpose is. And then when in other places here, we say the courts look at is some federal decision in line with state law and interests, rather than saying state law and interests, we say, is it in line with state law and the purposes of this chapter as set forth in something like that?
Yeah, I'll make a motion that we adopt it that way as a part of the statute and without reference to legislature.
Question?
David?
Go ahead.
No.
No, you go first.
I guess I hear what you're saying, but I feel like all the statutes are written by the legislature. I mean, they are that's their, that's what they do and so the purpose is definitely going to be what the purpose of the legislature is, to enact these laws. And so I don't find it to have any significance to take out the legislature finds and
Is this
declares.
something that should be in the Business and Professions Code?
I'm sorry?
Should this be in the BNP Code?
It could be.
Yeah,
You can codify this.
yes, I would prefer it to codified, because if it was just an uncodified section of some bill, nobody's going to know it exists.
Exactly. Yes, definitely can be codified, but I don't think there's a distinction to take out the language the
Okay.
legislature finds and declares.
Then I would also, because some of the later on purposes and whatnot, I think might also fit in this section. The specific one I was looking at was in the enhanced purposes, which is the next one, subdivision A. So the purposes is for your free and fair competition, healthy marketplace that helps everybody, and protecting competition includes protecting competition between businesses when they compete for workers, and prohibiting anti-competitive business practices that impede workers' freedom and to choose employment. I would include that in one of the fundamental purposes of this whole enterprise.
Mr. Chair, that was basically going to be my question is, can we mix and match these? Because there's a couple of pieces from one of the later proposals that I like. I don't like the whole thing, but
Same here.
yeah. So
We can, and one route to go would be to not, do a motion to adopt any particular legislative finding and declaration, but to say, okay, here's what we like, here's what we don't like.
Yeah, I
And
think we
then
should.
ideally, we would come back to you with something that isn't like all these different options, but it's like, this is what we heard, this is what you think we want, that you want, did we get it right? And it would just be one in one place.
So
Does that
far,
make sense?
yeah. So far we will propose one of these. It'll be codified, and what's in there is going to be cobbled together from pieces of the various proposals. Like, for example, the parts that I like are on pages 18 and 19. It's subdivision D and E.
Right. And my thought there was to have in this first article in the Cartwright Act, have one new section that expresses the underlying purposes of this in the first place, and a second section that has whatever guidance we want to give to courts in their work on these.
Kara, does that make sense? Yeah.
Yes, that makes sense.
This end of the this end of the table concurs. Could somebody put that in their notes that I want those two particular paragraphs? Thank you.
And Commissioner B has a question.
Oh, yes.
It may be foundational, but what's the difference between the basic purpose statement and the enhanced one, other than the obvious? I understand that we can mix and match, but are we trying to come up with one statement that will be codified? I'm just not clear on how these work together.
Well, what I was envisioning was to have a section that says what the fundamental purpose or purposes of this is, what's in the basic purpose plus subdivision A from the enhanced purpose statement. The other ones in the enhanced statement, I don't think I'm not that fond of. One is just B is um, wringing of hands, kind of a paragraph. C is expressing unhappiness with federal courts and narrow application of federal law. And D is basically the same thing as A. So my thought was take this is fundamentally about health, protecting free and competition, healthy marketplace protects participants, as well as protecting competition that, or anti-competitive behavior that impedes freedom of workers as the fundamental purpose of the new statute.
So you like A and nothing else.
Right, and none of the others.
Yeah.
That'd be my thought. As opposed to expressing discomfort with, federal jurisprudence.
Yeah.
Or screwing things. That doesn't strike me as something that ought to be in state law.
And could lead to more opposition
Yeah.
to the statute generally. Again, the concept we
Right.
we want to get this through the legislature.
And anyway. So yes.
I think that's a very good point. I wholeheartedly agree with you on the hand-wringingness of subsection B. That's just commentary,
Yeah.
like cable TV commentary.
Yes, and so is C.
Is everybody okay with including D and E from the next proposal?
From the the one that starts on page 17?
The one about California's laws and preferences starts
Yeah, I
on
would-
page 18. D is on 18 and
Yeah.
E is on 19.
Can I just recap to make sure I'm following along? What we have so far is, yes, come back to us on the basic purpose statement. And yes, come back to us on subdivision A of the enhanced purpose statement.
Yes, as one
As
section.
one thing, yeah. It's all got to be in.
And now I'm asking if we can add D and E.
But not to this one. There'd be a second section on guidance to courts, right?
Yeah, that's
Yeah.
fine. Yeah. As long as it's in there somewhere.
Okay, so then the next one, I think, and correct me if I'm wrong, Commissioner Carrillo, but I think you're looking at the language that's starting on page 17 and on page 18.
It's bottom of 18 and top of 19.
Yeah. And I would start with the one on 19 first. That's the overarching.
Yeah, good idea.
With the addition that's limited to subject matter.
I would say I might, because the stuff in strikeouts actually was a little more explicit. It says federal precedent interpreting the Sherman Act. So
Right.
maybe.
Yeah, so earlier, Victor and I were kibitzing about rewording the not strikeout part as federal antitrust law is not binding on California.
Yes.
Yes.
Yeah, something like that.
So it makes it subject matter specific.
Right.
It gets rid of the shall, and it's consistent with the persuasive clause that comes afterwards.
Take out the second persuasive.
Yes.
And then what I would say in the very last word in E, rather than saying consistent with California law and interests, say consistent with California law and the purposes set forth in the section we just put together on.
Okay.
Does that make sense?
Yes, it does. So then I would like to go back to the commission's views on A, B, C, and D. So that's starting on page 17 and 18.
I think Victor doesn't like A, and I'm a little concerned about it too.
Yeah.
Yeah, if it's in the California Supreme Court opinion, it's there.
There. I probably don't add A. Actions that unreasonably restrain trade, monopoly.
Do we need B? I mean, it's essentially
I don't know if that needs to
It's
be.
duplicative of the
It's-
text.
Yeah. That's
Duplicative.
Yeah,
like that.
it doesn't add anything.
The merger guidelines paragraph,
Hmm.
I don't know.
Does the text refer to monopsony?
Yeah.
Huh?
You said B is duplicative. Does the text refer to monopsony?
No, and somebody wanted that.
No, monopsony is in option 2.
By words?
By words, yes.
Okay, all right.
Monopoly or monopsony.
So for subdivision C, is that something you would like us to work on more? That's the 2023 merger guidelines.
I don't know. What do people think?
I'll be honest, I don't know what they say.
Yeah, I have no idea either.
Cheryl?
Well, they're a rather comprehensive document that represents a restoration of some of the more vigorous enforcement policies of the past before the Chicago School, and represent was essentially guidance of how the federal agencies go about evaluating. And they've, for instance, restored the historic thresholds of what was considered to be a highly concentrated market. And they've set forth in the guidelines the presumptions that you will see in the merger paper. They also talk about nascent competitors and how you should be looking at acquisitions of companies that are would-be or likely competitors. The guidelines do a lot to kind of push back on some of the most restrictive federal jurisprudence and has been used by the Biden administration as well as the Trump administration to indicate to business how they're going to go about interpreting the law and applying it.
Mr. Chair?
Yeah.
So consistent with my philosophy of not wanting to tie California law to federal law, like philosophically, I'm troubled by this. And I don't know if it would be appropriate, but I'd be interested in what Dan and Eric think about whether we should include C or not. I don't know if it makes sense to call them back up.
Yeah, that's fine. And while they're coming up, my instinct is if we're going to include some reference to those, rather than saying courts shall harmonize their rulings with, it might be something like consider or
We can make that persuasive.
yeah,
but not
persuasive
binding.
kind of thing.
Yeah,
'cause
I'd be more comfortable with that.
I'd rather not be telling the courts
Right,
that they have to be consistent with whatever that says.
right. Because Kara was making a point earlier that could be superseded by facts on the ground or like other relevant statutory changes. I wouldn't want to set that in stone.
Eric?
Well, I stood up here to tell you I don't really have a view on this because I haven't thought hard about it. There's a tension between saying that California courts shall comply with federal guidelines. At the same time, we're saying we want to distance ourselves, obviously. The suggestion I have is, and Cheryl can confirm this for me because I'm not as familiar with the guidelines as she probably is. They relate to mergers and acquisitions. I would defer that to whatever you're going to do with mergers and acquisitions and deal with it at that time, as opposed to dealing with it in connection with, the single firm conduct piece. That's my suggestion.
I like that.
And Cheryl, just a naive question for me. Given the whole change of things in the new administration, the presidential administration, are there going to be 2027 merger guidelines? I mean, yeah.
The Trump administration has said that they are going to abide by the 2023 merger guidelines, and that it's important to have stability in our antitrust enforcement.
Okay. And then let me ask about D, because I think, I'm sorry. Oh, but Dan.
Sorry, yeah.
D for Dan.
The opportunity.
Yeah, Dan.
Yes. Yeah, I would omit those for a couple reasons. One is, we're talking about single firm conduct. We have yet to talk about M&A, and these are the M&A guidelines. So that ought to be part of that conversation. Also, as I mentioned earlier, Connecticut did try to codify these, and it was a complete disaster. It didn't get out of the first committee. They have been President Trump has said he's going to use these, and it did come out of the Biden administration, but they're not without controversy. And as demonstrated in Connecticut, which is also a blue state like ours. So I definitely wouldn't put them here, and I defer that discussion to when we talk about M&A.
Okay,
Thank you.
thank you.
And just to note, and Sarah corrected me if I'm wrong, but I do believe that we have something in the merger draft language related to the guidelines.
We do.
do.
Options 2 and 3 directly reference them.
Okay. And then my question was on subdivision D. That doesn't strike me as, other than sort of pointing out to somebody what courts have said. And I don't know that we need to do that in statute.
To me, the reason for having that in there is in case the Ninth Circuit actually reads it. It's speaking directly to federal courts.
That's why it's because so much of antitrust litigation ends up in federal court, and Cheryl can tell you exactly how many times it does.
Yeah, I
This helps.
virtually all of the antitrust goes to the federal courts because of CAFA, the Class Action Fairness Act, which requires all class actions, even if they're only under California law, to be tried by federal courts. And if you plead any cause of action under the Sherman Act or Clayton Act, the federal courts have exclusive jurisdiction over those. So you are actually state court judges, contrary to what we heard here, actually do have a lot of experience with some local antitrust cases. So there are a lot of judges in the complex courts in Los Angeles and in San Francisco and up in Sacramento that do hear antitrust cases that are local, that do not have federal antitrust cases in them. And all of these propositions are really written to the federal courts to say, don't conflate the Sherman Act with the Cartwright Act. And oftentimes the judges will say, well, you really haven't told us how the Sherman Act is different from the Cartwright Act. So I'm just going to say the two are a pair. And so this gives you some guidance to those judges that the laws are different in some very significant respects. And the one on maximize, I know that Commissioner King doesn't like the term maximize, but that really goes to the heart of one of the core kind of principles of the Chicago School, that we should defer to the market and let the market just take care of itself. We should be very wary of any enforcement. And it sets a different tone to say, no, we don't buy into that. It is our state policy that we want to aggressively or robustly enforce our antitrust laws. So I would hate to see us jettison A. We could fix it.
So this, if we incorporated this into our guidance, this would be guidance in state law to federal judges who are adjudicating class action suits that end up in their court as opposed to our court.
Not only class actions, but let's say they're going after Amazon, Google, Meta. Those cases typically involve federal antitrust claims as well as state antitrust claims. So the federal judges are going to be deciding our state law.
They adjudicate,
Yeah, so they have federal question jurisdiction on any federal claim, which the Sherman Act obviously is. But if there's also a Cartwright claim in the complaint, federal court hears that too.
They have exclusive jurisdiction.
Yeah.
I learned something new every day.
So that's why federal judges, is important that we talk to the federal judges who are overburdened. And in fairness, a lot of times the parties kind of run out of space in their briefs to say how the California law is different.
Yeah.
Maybe they don't even know what the California law is.
If I thought it would get past Ledge Council, I would put this in bold.
Yes.
And underlined, right? Okay.
Okay, so I think Cheryl just made a pitch for us continuing to work on A. What do
Yes.
folks think about that?
I had a thought about that. There are a couple of things in D that are in quotes. And you mentioned earlier that that exact term, maximal or maximize, is a quote from a California Supreme Court case. Can you put that in quotes in this first sentence in D with another semicolon?
Mm-hmm.
So I have two semicolons, three separate clauses, each with a quoted thing, and then cited in the footnote, whatever case you got it from.
We could also include the court.
Yeah,
We could do it as the intent of the legislature to codify the holding and blah, 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 that. I don't know if it's really a holding or is it more of an indication, but it's something we could certainly
You could
look
say this
at
is
further.
declarative of of those decisions.
So all of that is from the Supreme Court or cases, or just the phrase about mindful the California favors maximizing deterrence?
I'm sorry, on A?
In A,
I think that's a Clayton case and they say that California law favors maximizing deterrence of antitrust.
that's phrase.
That is exactly from the,
Yeah, okay, no, well, what I was
Case.
wondering if,
Shall liberally interpret, does the court, does the case say that?
does the case say that? So
Unfortunately, I
what I was
didn't
wondering is,
quote it.
could it read something like, could it read, courts shall liberally interpret California's antitrust laws to best promote free and fair competition and be mindful that according to the California Supreme Court, California favors maximizing deterrence and antitrust protection violation.
I'd still put it in D. I'd put all that together in one place.
So is the will that we continue to work on it? We're getting feedback and we'll massage it and
Okay.
I'll try to put on that legislative council hat that I had from many, many years ago. So we keep Kara, our commissioner, happy and not thinking she's gonna have to rewrite everything when it gets to her. Okay, so it sounds like B and C are out. Is there any more
E.
discussion on that?
I mean, I'm not opposed to just keeping B for now until we see everything together, instead of taking it out and then not remembering that it was potential language. Unless you're gonna just strike it out so we see that so we can still kind of remember what was there.
Yes, there was one of these where we somehow the strikeout was omitted, but yes, the intent would be that you get to see
Okay.
this clean or not clean, that you
with
get to
the
see it
strikes.
with the strikeout and add indicated, so you know what was changed.
Okay, thank you.
And please keep E.
And then we also, I think we have direction to keep working on E.
Yes, federal antitrust law shall not be
Yes.
binding. And take out the second persuasive and then.
Federal antitrust law
Very, very
is not
persuasive.
binding.
Federal precedents, is that where we are now?
I think we are. That is on page,
19.
yeah, starts on page 19.
Could we take 5? Could we take 5?
Take 5? 5-minute break? Is that good,
Maybe 10.
everybody?
'cause
10?
Is that okay?
probably.
I don't want to declare myself king of the commission, but
Okay.
We were on page 20,
20.
19, 20.
Oh, okay, this was
The federal precedents.
Yes.
So what are, so. I'm gone.
Yes, Anna's gone, but we still have,
Maria still, we still.
we have 5, yeah.
What do people think about?
Uh-oh.
I don't think we need it.
I don't think you're.
Sorry, I turned off my thing. So what do people think about the issue on federal precedents?
I agree with Commissioner Carrillo's comment that we don't need to make reference to it. And furthermore, again, with my theme of enactability, we don't need to go around poking bears here and getting teams of lobbyists to take down our legislation. If the courts have ruled thusly in these three cases, the courts have ruled. We don't need to, put an exclamation point behind it by putting it in the statute. It'll just get a lot of additional opposition perhaps, but Cheryl seems to think I'm missing something.
Just say, we're not overruling any precedent. We can't overrule precedent, and it's going to continue on the books. All we're saying that interpreting our new California law, we're not going to require that you show this particular element that the Supreme Court in a federal case required. So for instance, I think one of our guest speakers was talking about the Brooke case, which is predatory pricing. And in the old Chicago school, it was thought that nobody in their right mind is going to engage in really predatory pricing, where they're pricing below cost, because that would be ruinous. And then all the competitors would sweep in and the market would correct itself. But now we know that there are players in the marketplace where predatory pricing allows you to get rid of a competitor or seriously handicap a competitor. So it does make sense to do predatory pricing at some time. So California has already said, if you want to do predatory pricing, you don't have to show recoupment. That's already part of our California law. We've already said if you pricing below cost, we look at a fully allocated cost basis. Federal law looks at marginal cost. So we make it much tougher. We make it easier to show predatory pricing than federal law does. We have really very different standards of predatory pricing already. So again, this is a message to the federal judges who are probably going to hear and interpret our new law, because these cases, a big case is probably still going to be coupled with Sherman Act claims. And we're probably still going to have a lot of federal judges deciding this. And this is saying, in this case, we're just not. So what we say about Brooke is that in a claim of predatory pricing, you don't have to show that the defendant is likely to recoup the losses it sustains from below cost pricing of the products or services at issue. That's already the law in California. So we're just kind of reinforcing it. And on Trinco, you heard one of our commentators say the essence of Trinco is that, you don't make a competitor assist another competitor. Well, there's nothing in this language that even talks about requiring anybody to assist a competitor. Instead, what has happened is cases that have interpreted Trinco have come up with different provisions that say, well, you have to show that a defendant terminated a prior relationship with somebody. And we're just saying, no, if you applying Trinco, we're saying that you can look at that under California law if you want, but we're not going to require a finding of that particular element. It doesn't really go to the basic precept or holding. It just says a couple of these interpretations or limitations courts have placed on certain cases are not going to be or should not be part of our California law. You can go ahead and consider them, but it can't be a mandatory part of the law.
May I be briefly heard on this?
Yes.
Certainly. Eric Ensign with Kroll and Mooring on behalf of the California Chamber of Commerce. As I said earlier, I think the idea of specifically calling out cases and particular fact patterns and holdings in those cases is problematic for a number of reasons. I think we're all in agreement that when it comes to California law, federal precedent is not binding on California courts. We're all in agreement on that. It's not binding on federal courts either when it comes to California law. Leave it at that. If those courts want to consider Trinco or Amex or any of these other cases and finds them persuasive, that court can use them. If it doesn't, then it doesn't need to use those cases. It's not bound by those cases. Let that stay. Because if we say we're rejecting these things, or it's not necessary to prove a California Car Right Act violation, that means disregard the case, and it shouldn't be disregarded. It is precedent. It is out there. People should think about it and consider it when they're looking at the law and applying the facts to the law. And that's all I'm saying is let that standard stay and let the courts make the decisions of whether these cases apply or not. They are built on economic thinking throughout the years, and the court should at least have the benefit of considering that, whether they reject it or not.
And I'm sorry, these, are you talking about state courts or federal courts?
Well, it would be both. I mean, if a state court is considering the Cartwright Act in state court, the federal precedent is not binding. Even in federal court, someone correct me if I'm wrong here, but I believe this is the law. Even a federal court that is deciding a Cartwright Act case needs to look to California law to decide that issue. And federal precedent is not technically binding on that federal court as to that issue.
So isn't that the statement we want? Rather than referring to 3 specific cases, that actual statement is the concept. And that actual statement isn't really covered by our prior language saying that federal law is not binding but should be persuasive. That's vaguer. You're saying something more specific. So I'm wondering, should we just, instead of singling out 3 cases, have another statement about how federal law interplays with California, but in a more structured way, as you're suggesting, rather than the earlier, vaguer statement that we've been making that federal law should be persuasive, but it's not binding on California courts?
Well, I don't know that that's necessary. I mean, the law is what the law is, and perhaps the federal courts need a reminder of that. And I think that's already covered in one of the things we already looked at earlier.
Yeah, it's in D&E.
D&E. And I think that's sufficient to get the point across that when considering a Cartwright Act claim, whatever that ends up looking like, federal law on the federal Sherman Act is not binding on any court.
So Cheryl, since there's at least 2 commissioners are uncomfortable with the concept of singling out 3 specific cases and putting an exclamation mark on them, does D&E capture the concept, or do we need another statement of some kind that would address these concerns that the federal courts will run away with things and still try to apply Brooke, Trinco, and Amex despite D&E?
Well, D&E is already the law. The California Supreme Court has said in Aria, we're trying to remember the third case, Cipro and Chiance, we are not bound by federal law. You can look at it, but the federal courts, it doesn't matter, the Supreme Court has said this at least 3 times, continue to conflate federal law and state law. And unless we lay down some guardrails that protect against that in a stronger way, they're going to disregard what the California Supreme Court has said. And by putting it in a statute, we can limit some of these precedent that have a very deleterious effect on our enforcement abilities. People think these 3 cases really limit our ability to police our own marketplaces. And to just say, well, we'll just see if some California court or some future federal court decides to ignore federal law and go in a different direction under a Cartwright Act, we've taken away a lot of potential progress that we could have made.
But it seems to me there's got to be a middle ground of some kind. Can we explicitly say you shouldn't be following Brooke, Trinco, and Amex without specifically mentioning Brooke, Trinco, and Amex in the way that it seems to be referencing here?
I
that's-
think these don't specifically,
Well, you're going to footnote it, right?
right?
And it'll be obvious to any practitioner
Yeah,
that
okay.
that
Yeah.
laundry list of items is
Right.
referring to those three cases.
Right.
My point is you don't need to do that. The law is the law in terms of what controls in Cartwright Act cases. And saying these things in a
But that actually
statute.
cuts both ways. Because if it's already there, well, why not mention it then?
Well, let me
It
say-
really cuts totally.
And let me
both
put
ways.
it, let me put it this way then. Cheryl and I obviously have a disagreement on the importance of these cases and whether they're decided correctly or wrongly. I'm not sure I'm right. I'm not sure she's right. It's a dispute. If we allow the courts to work it out, they will. In every Cartwright Act case I've had, the plaintiff's lawyers have always made the point that the Cartwright Act is different from the Sherman Act and that federal law does not control issues under the Cartwright Act. That will continue to happen. We don't need a statement in the statute that calls out these cases.
But
The
Cheryl's
courts-
saying that federal courts completely ignore that
I-
statement.
And I agree with Eric on something. We found some common ground.
There you
here.
go.
And to quote Commissioner Carrillo earlier, you said it best. You said, this gives you a second bite. I mean, let's call a spade a spade. I mean, one reason to not cite the three cases is to create some billable hour moment for a law firm to come at it again, despite the fact that California courts have said, don't follow those.
Right. And
No, you've convinced me, Cheryl. So
I think-
I changed my disapproval of the three references.
Thank you. Mr. Chair, thank you, Commissioner King. I think this is going with D and E is a middle ground that makes everybody a little bit unhappy. It avoids the problems of singling out single cases. So one of the problems I have with that is looking forward. There are going to be other federal cases that a California person like me won't like and would want to add them to the list, but then they won't be on the list. And so a future federal court will say, okay, well, I can't consider these three cases, but the one that just came out, that's fair play.
And then a future legislature could add something to the statute.
Yes, I would rather go with the general proposition because it satisfies my goal of sending a signal to the Ninth Circuit and every federal judge who has to consider a Cartwright claim, but without creating that implied exclusivity of singling out three cases.
But you are giving them a second bite.
To an extent, it's unavoidable.
Yeah.
Because whenever you're doing a laundry list, you're going to leave some things off, and the list, you can't update the list every year.
Other comments?
yeah, again, I want to emphasize that we're not,
Commissioner.
Kara had
Oh,
something.
sorry.
Commissioner Jenkins.
You can finish because I was going to go on to something else.
yeah, I just want to emphasize that we're not overruling these cases. We're just saying, here's a particular element in this case that we do not feel should be part of California law and that it really impedes enforcement. These are cases that academics and experienced practitioners have cited over and over again as blocking effective enforcement against some of this anti-competitive conduct.
Yeah, Kara?
I just had a suggestion. It's probably not going to be something that my colleagues here would be in favor of, but since option one is still on the table, what if this specific findings and declarations were to correspond with that option? Because that seems to, kind of have the federal statement, but then also include the list of things that we're saying we don't like about the federal statement.
I think one drawback about that is in another, in the one where we're talking about, this is what California case law says, and that's kind of a message to the federal government. If it's just option one plus this particular legislative finding and declaration, then we would be missing that.
Missing what? I'm sorry, we're missing.
We would be missing the language that talks about California's range is wider and.
Oh,
deeper.
well, I guess
Yeah.
I don't mean to exclude that,
Maybe
but
I
I
misunderstood you. Okay.
I'm just saying that it seems to tie more into this option one. If we're still entertaining looking into option one.
We'd also be
Second.
giving up on single firm.
Altogether.
Yeah.
My,
So we could do the other round. We could graft that onto option one, but then you're basically
Right.
still working with option two.
Yeah.
my
Well, it's an
question,
I think we just need to have more, we need to have more options to examine the language. So I mean, I feel like we're kind of stuck in these three buckets and we should be able to, look at other options of how to examine these
Reconfigure
concepts.
things.
Yeah.
So would it be helpful to have analysis that explains where each of these subdivisions come from, what case it is? I know we broadly talk about Amex and the other couple cases, and I don't know if that's causing some discomfort with the language,
I mean, to actually cite them in the,
like we did with the other kind of the restatement of California law.
Mhm.
Then perhaps you would understand better what the issues are. I mean, it could end up being a lot of analysis because, as Cheryl's indicated to me, it's not just these particular Supreme Court cases necessarily, but how subsequent federal opinions have interpreted them.
Yes.
So I'm not saying it's an easy analysis.
I think one element that we're missing, Cheryl's too polite to say this. It's not a neutral mistake that the federal courts are ignoring this. There's actually a Chicago school mentality, and so what looks like overkill to single out three cases, three specific things, is really necessary because you have an activist Chicago school judiciary that's willfully ignoring the fact that Brooks, Trinko, and Amex don't apply. And that unless we're equally forceful in saying it, they are just going to just flat out ignore it every chance they get unless we just flat out say it.
Well, and I would add to that these three cases are ones that practitioners and academics repeatedly point to as major chokes in terms of effective antitrust enforcement. The defendants are able to use these precedents to avoid a lot of liability for their anti-competitive conduct.
If I may, and then I will sit down because I can get out of this conversation.
all right.
I just don't agree with any of that. I don't agree that these are roadblocks to antitrust enforcement. I don't agree that the federal bench is a runaway Chicago school bench. These are things that you may have examples of that. There may be instances where these cases interfere. I don't know. I haven't studied it. My point is, why are we inviting all of this now? It's much simpler and cleaner and more elegant to just note the law, which is that in California Cartwright Act cases, California law controls and federal law is not binding. That to me is the cleanest and the easiest rather than calling all of these out. Because if we're going to call all of these out, there are other aspects like the relevant market aspects, the market threshold aspects that you were asking about earlier that are identified in this laundry list. I'm not sure everyone agrees with those. And so if we're going to go down this road, you're literally going to have to go case by case and issue by issue and say, is it in or is it an out? And if we're going to say to a court, it's not required to establish a relevant market, for example, or a threshold of market share, that means it's not required, regardless of what federal court says. So if we're saying that, we are sending a strong, strong message to not only federal courts, but California courts. And I'm not sure that's the right message.
That is the law in California, but unfortunately, federal courts don't always respect the law in California. So we have a problem. We have road
Isn't there only
signs
so
that
much we can do
people
about
just
that?
blow through. So do we put flashing lights on the roadside?
I mean, we could just cut and paste the 10th Amendment into this statute. I'm not sure how much that would help, though.
I have more of a sort of what actually does this do question, because earlier when we were dealing with the guidance, you're not bound by federal courts, although by federal precedent, if you find it persuasive, you can rely on it. This looks to me like it says two different things. One, it says legislature finds and declares that the following may constitute evidence. Liability shall not require finding that. Is this intended to be actually create an obligation for the courts, or is this guidance?
As written, it's guidance. I think
I don't
one of the points.
necessarily read that.
Where are you looking? Sorry.
On page 20, the proposed
Yeah,
language of disavowals of
Says-
California case law,
it says shall not.
liability shall not require a finding that. And that sounds to me like that's as actually telling courts they don't have to make that finding, as opposed to guidance. It's like, what's it, captain, whatever. They're not rules exactly. They're more like what you call guidelines.
Looks like the pirate code.
Yeah, the pirate. Captain.
And Commissioner Simpson, that was my point, is if we're going to phrase it this way, we're telling courts that these things are not required in Cartwright Act cases.
Right.
It's not just if you find it persuasive, use it. We're actively saying these are not required. They're not elements. And that is the problem
That's
to me.
my concern.
Cheryl's saying that's correct, that California law does not require it.
Yep. And I mean, I think the whole point of working group one in proposing this particular provisions, most of which are also in Calera, is why have a single firm conduct provision that purports to differ from federal law? And we know the federal judges just by instinct conflate the two and treat them the same. So if you say here are some things where we differ, and here are some points where we don't want you to require this in interpreting California law, you have a chance of bringing some discipline to judges who might not be aware of what California law is.
Or can't we just say consistent with California law? This list?
Yeah.
Say what again?
I like that. It makes
Consistent.
it less like the legislature's scolding people.
Like a restatement of California law principles.
So under California law, today you don't have to do these things. Is that right?
Because there is no single firm conduct law in California. That's the reason it's not required in California law. There is no law. And what we're saying is we should at least allow California courts to look to federal law on these same issues when they are deciding this brand new law under the Cartwright Act.
Well, there is, we have something called the Uniform Practices Act, which outlaws predatory pricing. So in that sense, we already have law on predatory pricing. It's in a different act, and so it's rejected recoupment and the measure of costs that federal law applies.
All right. What do people want to do? Yeah.
Briefly, if I may, just one thing I urge you not to get rid of, it's not a Chicago school thing, is this notion of relevant market. What are we talking about? And market share. Like today, this is a law that's aimed at big companies that can push people around. But if you take those two things away, anybody could be liable. A tiny little store could be liable because you don't have to show relevant market or market share. And the case I cited to you, Earl Warren, was not Chicago school. I think he was way before that. And Thurgood Marshall, I don't think of him as Chicago school. Acolyte, Robert Bork, lots of people way before that. These are the tools they used, and it's super helpful. If you get rid of these things, then this is a law that applies to everybody on Main Street. I think it's not what you intend, or if it is, please let me know. I want to understand. But it's the piece at the end that really is quite dangerous in my view.
Well, I think it's fair to say that both federal law and state law allow you to prove market power, market effects by direct evidence and by indirect evidence. And by direct evidence, you would show evidence that the party had raised prices, it reduced output, it had done something else to directly impact competition. And the second way to show market power, market impact would be with indirect evidence, which requires, which usually entails a market share analysis, which is done by experts, which costs millions of dollars and makes a lot of antitrust cases inaccessible to a lot of people because it costs so much to do market share analysis when the direct evidence is more probative and demonstrates the market power of the defendant. So this actually represents the law, but the law, again, is one that the courts often disregard and require you to show up with a very expensive expert report, even though you have great evidence of the market power and market effects. So this is, one way of trying to make antitrust a fair, a more even playing field.
I'll sit down. Thank you. But it's to Commissioner King's point, it's an enactability thing. If I have to go to every small producer and say, now you have to hire Eric to give you advice on every single thing because, before it was 70% of the market and now you're making one movie. I've mentioned earlier that this was all conflated in other law and there used to be a presumption of market power just for one thing. I think that's a mistake, but I'll leave it to you.
Is it more of is this an abuse of dominance issue? I'm trying to see how this conversation differs from what we're going to have in a short while, maybe on the market, what do you call it? Misuse of market
That's what
power.
we call it now.
Yeah, okay, sorry.
We're never going to say abuse of dominance.
Yeah.
That makes it too European
Okay.
and too unpalatable.
This is an issue that affects, and then the analysis in single firm conduct. Let's say you have exclusive dealing, the court's going to look to see market foreclosure, and various conducts are going to look to see how the market is impacted, and you can do that with, as I say, direct evidence, or you can do the market share analysis, or both, if you have lots of money.
Victor?
I don't think we're going to solve anything this afternoon. So since we're giving people time to keep drafting, I'm not wholly convinced it's either or, that there's binary, that we have to just go with D&E or we have to make fairly explicit reference to 3 cases. There has to be some way to say that federal law is not controlling, but can be persuasive, but not necessarily single out 3 specific cases in the way that's getting everybody's hackles up, or at least certain lobbyists' hackles up. So can there be another way to sort of skin that cat? Because D&E is a very general principle.
That's what I like about it.
And yet these are very specific principles.
That's what I don't like about it.
There's got to be some language because it's just so binary right now. It's just kind of extreme difference.
You could do this, you could do as including but not limited to, and then give like a brief description of some of these.
Yeah. Rather than,
Use them as
because generally we have a discomfort at singling out 3 cases.
Yeah.
Why those 3? Why would you do that?
Yeah, so that's one of the things I don't like about the list is that, exclusio unius, that's a problem in interpretation. And there may be an instance where a judge wants to use one of these because it's appropriate for the particular facts of the case, but then they're dissuaded by this.
So maybe, just thinking out loud, instead of just the D&E statement that federal courts don't control, maybe even call it the fact that because federal courts have ignored the concept that federal courts don't control, we want to really emphasize that federal courts don't control. I mean, call them out for having ignored the California law as they've done.
Nervous about putting that.
Yeah. You think that's going to enhance its chances of passing?
Voting or anything like
Those
that.
idiots in the federal courts don't,
Yeah, I don't know about that.
But that's what we're getting at. We're trying to address the fact that there's a movement, or whether or not they're all Chicago school or Thurgood Marshall or Warren people, but there are people who are refusing to honor California's preferences in this area, just flat out refusing and looking for any excuse to do that. So I'm sympathetic to Cheryl's concern that from her experience, that there's just a wholesale federal courts who are just going, we don't care. We don't care. California is irrelevant to us. So I think we need to address that, but there's discomfort in singling out 3 specific cases that way.
And I think it could be done tactfully in drafting it in terms of, the legislature always makes statements that they're addressing a specific concern in enacting these provisions. It doesn't have to point fingers at the courts necessarily, but it could say, something on the broader issue that, there's been confusion about which laws apply, and we're trying to clarify that. Something to that effect.
I like that.
B.
Yeah.
Assemblymember Pacheco.
Yes.
And I don't think we can hear
hear you.
you. Is your mic on? Uh-oh.
Wrong button.
She's gone.
Or maybe she was saying she needed to leave.
Oh, I had my hand up. If we kept D and E, and I don't know if we are allowed to footnote in this section, but D and E and then a footnote to, for example, or including but not limited to, and sort of summarizing the issues as, not in the list as they are now, but summarizing them. So at least it's clear what the concern is.
Typically, no footnotes in
Yeah.
statute. Yeah.
No footnotes.
What about a commission comment?
Could do a comment.
Mission comment in statute?
Well, not in
Not
statute.
in
no.
statute.
We don't?
Nope.
I thought we've done that.
I thought we had.
The commission comments are published in, they're called West Endearings, or is it Lexis and Westlaw these days?
It's in the use notes.
After the statute.
Right.
So it's a way of gleaning legislative intent.
I like that. And legislative intent is important.
But that's not something that the legislature controls. The legislature
They would-
enacts the statute.
That's correct. They would see the comments, I believe, if we made a recommendation to them, the statutes would go with whatever comment language we have. But no, it would not be it would be evidence that the legislature saw this. That's what they intended to do if they adopted the statute, but it's not the same as the legislature saying, this is what I want to have in statute.
And it wouldn't be in the code itself.
No, it would be in the annotated, yeah.
West's, West's something that some publisher sticks in.
But if some federal court was blatantly ignoring California law, some good law firm's going to find it and say, hey, this was the legislative intent. Stop doing this, federal court. I like where this is headed. And if it could be a comment, as milquetoast and weak as that is, it still goes to the issue of enactability. We don't want to go around writing things that are just going to get hordes of lobbyists to shoot this whole law down.
So are you thinking of a comment that would sort of say something like this section is intended to address the holdings and blah, 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 which,
If it's in a comment, I feel better about it.
okay.
What do you think, Kara?
Legislative intent comment.
Have to see.
Long
It
comment.
seems, yeah.
Can we see some language?
Yeah.
Yeah, well, you can draft short, medium, and lengthy comment example.
Three options, three
Yeah.
options.
Just give us the full version. We'll red pen it.
So just trying to walk the thin line between Cheryl's concern that unless we're stronger, federal courts are going to ignore California law. And yet, if we're too strong, we're going to get lobbyists making all sorts of hyperbolic arguments saying that we're being too strict about these three cases.
The commission comments also easy for the legislature to edit out if they don't want it.
So what's the direction?
Maybe give us some non-statutory options
Okay.
for
That will make E and D stronger.
make it at least more explicit.
It'll be a specific general principle.
Yeah. Something like that. I don't know.
Okay, well, we can continue to work on it. I also
Okay.
think it would be helpful. Because at one point, hopefully, I'll have to explain to Judiciary Committee staff where this came from. So I think it would be helpful to know,
What it is.
yeah,
and where it came from.
why did you have this sentence and what case were you relying on when you crafted that? I mean, even for the purposes of the comment, anyway.
Okay.
That's what us lawyers look for.
All right. Next issue?
So the other public comment, okay, so do you want us to look into the idea of the Attorney General should draft rules at all? Okay. I'm hearing no, no one likes that. Okay.
And then
I
federal, yeah.
don't, unless somebody is concerned that the memo didn't address it, I think we're good with that one.
Okay.
And then the lapse thing was monopsony. And I think, there's nothing further we need to do. Okay. Okay.
Right. So does that wrap up single firm?
It does.
For the day.
Thank
For
you.
today.
Yeah, just for today. And you gave us a lot of homework, so
Okay.
we'll be back at it. On to the next thing, mergers. Okay, so Sarah is actually going to be talking about this more than me. She was delighted when I said, "Oh, you're going to be doing this one," because I can't talk anymore. But I have to give Cheryl and Sarah credit because I was a reviewer. Let me put it to you that way. But so this one presents staff recommendations for draft legislation addressing mergers as the commission directed staff to do at the January 23rd, 25 meeting. One thing that we don't do in deference to SB 25, the Umberg bill, is we don't have anything that would relate to notification, merger notification. They're like similar to what we did with single firm conduct. There are 3 base options for California law to regulate mergers. And then we put the advantages and disadvantages of each. And is it 3 base options? 4. Okay. At one point there was 3 and then it became 4, but we didn't change 3 to 4 there. So Sarah will march you through the options. I don't know if you all want to hear a lot on the background on current merger standards. I'll leave that up to Sarah to do succinctly. It seems like it's getting late and you probably are more interested in the options. Like we did with single firm conduct, we're not asking for any decisions today on this. To the extent you have feedback or questions, that is very helpful, but the thought process in doing it this way is it really gives folks longer than, 10 days or whenever the memo was posted to come up with public comment on these complicated topics. So that is why we think, and it sounds like based on today, that it was very beneficial to get that kind of robust public comment for the commission to consider in its deliberations. So Sarah, can I turn it over to you?
Thank you, commissioners. I did provide some additional background on the current merger standards and burdens of proof. Did anyone have any further questions on that?
Sound like it?
Okay, great. Moving on, I just wanted to frame how we came up with these four options. And we tried to base it on the single firm conduct structure, starting out with federal law. But in contrast to single firm, where we could kind of integrate parts of the Cartwright Act, the available California law on mergers is not comparable. We do have specific law on nonprofit healthcare systems and groceries acquisitions, but in the former, it requires notice and agreement from the Attorney General. And the second one, it requires at least notice. And I think that's not where we understood the commission was going for these options. So the first is based on the Clayton Act. It is, I did my best to take the operative language. We did trim it for some comprehension. I removed the section about common carriers because we've taken care of that in the PUC. I will note an error and it's in the next section. And then we take the base from option 1 and then add to it the Philadelphia National Bank Standard. And the idea here is that federal law became a problem. The interpretation became a problem once the Chicago school moved into dominance. But at the point of Philadelphia National Bank, it seemed true to the idea of preserving competition. Philadelphia Bank does not set a threshold, but in that particular circumstance, it determined that 30% for this particular fact pattern was probably too high. So that would reset the base standard from where it stands now and give courts a body of federal jurisprudence from which to draw kind of up through this holding. We consulted with some other folks, one of the members of the mergers and acquisitions group and some other practitioners. And the actual language that's used in subdivision B, which is unfortunately missing the word affects at the end of the first sentence in subdivision B, is recognized widely. In addition, we do make reference to the 2023 merger guidelines because they do speak specifically to mergers and acquisitions. We did note that they should be considered persuasive authority and understood to complement and be harmonized with this section. So it's meant to give guidance to the state courts. The third option builds off of this option in as much as it contains basically the first two. And then instead of suggesting the merger guidelines as persuasive authority, it actually takes one of the guidelines that speaks specifically to what the current federal enforcement authorities look to as far as specific calculations determining market concentration and to what extent that is considered sort of a problem in violating the current standard. There is some argument then the text goes into as to whether the federal guidelines exactly interpret Philadelphia Bank. It also is a more restrictive standard. On the other hand, it does give courts some very definite parameters by which to judge these sort of circumstances, and certainly all entities are subject to these guidelines currently. So this would.
Sarah, sorry to interrupt. This might be a good time before we move on to option 4 to see if commissioners have any comments or questions.
Comments or questions? So give me the distinction between one and 2 is, and what's being codified in the Philadelphia National case?
So
in 2?
Sure. So particularly in option 2, subdivision B is the actual language from Philadelphia National Bank that says may produce a firm controlling an undue percentage share of the relevant market. And in this particular case, it was determined to be 30%. So it implicitly sets a a ceiling of 30%. But it,
But it doesn't say 30%.
correct. However, it does also not only reference that case, but then it looks to the 2023 federal merger guidelines that further interpret that case, that give more concrete parameters for evaluating mergers and is directed as persuasive authority, but it does not bind the courts going forward.
Okay, as a practical matter, what does this do? It says, is it, if it produces a firm, is the effect of this, if the merger produces a firm that results in more than 30% of the market, that is deemed unlawful?
Yes and no. The understanding is, and I look to Cheryl for some assistance, is that we're not prescribing a 30% amount here, but it
Right.
refers to a case in which those facts speak heavily to the importance of competition, generally speaking, and then set the level, and they are at 30%.
So the holding wasn't, okay, 30% is the magic number. It was looking at the particular circumstances in that case. Is that correct? And another reason to codify this one is in talking to Cheryl, this is another instance of, this is still good law,
Correct.
which should make it non-controversial. It's never been overturned, but for whatever reason, it's not necessarily being followed by lower courts.
Even though it's court, federal courts ignore it. But the real importance, so we call it a structural presumption. So it shifts the burden of proving that the merger in a heavily concentrated market is not going to hurt the people. Instead of the government having to prove that the merger is likely to hurt the people, and the merger hasn't taken place. So you're dealing with an incipient standard and you're trying to take a crystal ball and say, oh, is this going to hurt the market or not? And Congress at that time, Philadelphia National, was very concerned that we had an increasing consolidation, and the court was reacting to that and said, well, look, when we have highly concentrated markets and we have a merger that's going to increase that concentration by a significant amount, we're going to switch the burden. And we're going to make the merging party prove that to provide evidence clearly showing the merger is not likely to have such an anti-competitive effect. So that's the importance of it, is the shifting of the burden.
Okay, so that's,
I didn't hear any of that.
Sorry. I'm an idiot. Okay, I turn off my, shall I start over?
You can just give me the Cliff Notes.
yeah.
The importance of Philadelphia National was a U.S. Supreme Court case in 1963. You would think that, okay, it's the U.S. Supreme Court, so it's the law of the land. Well, antitrust is populated with all these Supreme Court cases that reflect different ideologies and different time periods. And so you can find cases that really kind of conflict with one another. So you can be very selective in what you choose. But in 1963, in this Philadelphia National case, the court said, look, in highly concentrated markets where you have a merger that's going to increase the concentration of an already concentrated market, we're going to switch the burdens and we're going to make the merging parties prove with evidence that clearly shows it's not going to be an anti-competitive market, anti-competitive merger. Normally in a merger, the government has to show that the merger is likely to substantially lessen maybe to substantially lessen competition or tend to create a monopoly. So by definition, we're dealing with probabilities as indicated by the word maybe. So everybody pulls out their crystal balls and said, well, I think it's going to be really a wonderful gift to the nation and we're going to do good things. And then the government has to say, no, that's not going to happen. What's going to happen is prices are going to rise or people are going to be laid off or what have you. So by shifting the burden, you reduce the burden on the government and make it more likely that these more troublesome mergers will be limited.
So
Thank you.
the difference between this, so in option one, the burden is on the government.
Yes.
In option two, if it's a raises the concentration, creates a firm's market share north of some number, which is
About
done by
30.
that complicated formula of no. or-
Not necessarily. So we referenced the HHI index, but it's advisory. For this particular, by including the language from Philadelphia Bank, the intention is to sort of peg it at 30%, but they can also use the HHI as well.
Okay, that's the merger guideline stuff. Okay, so but there'll be a determination of what the market share threshold is that shifts the burden.
Yes.
And but it leaves a lot of wiggle room for the courts.
What, ma'am?
In determining what the threshold is, correct? It's like
They-
around 30%, but it doesn't lock them into that figure exactly. Is that fair to say?
Well, this one leaves a lot up to the court to interpret, which is both a good thing and a bad thing. The other option is to give them very specific numbers and say, this is going to trigger the presumption, which is the next option. So this option gives the court more latitude in deciding when to step in and shift the burden. And that's consistent with California state law. The Cipro case, court said it's very appropriate to shift burdens where one party has the knowledge of some material facts.
Okay, and this would just apply to state courts?
I'm sorry?
Just apply to state courts? This,
Well, a merger is, if it's challenged under state law, presumably you would want to go into the state court.
This is
If
for
you wanted to
California.
plead both a Clayton Act and a state law, then you'd have to go to the federal court. But I would presume in a monopoly where you have a lot of local impact and you're not partnering with federal enforcers, that you might want to be in our state court.
yeah, so we're putting this in the B&P code or somewhere like that, so would presumably is to be, and if someone files a whatever suit under this statute, it would go to state court.
Yes.
But it could be potentially removed to federal court, depending on the specific factual circumstances or how it's alleged.
But this is the part of the exercise where we're trying to make California law for California courts.
Yeah.
Yeah.
Yeah,
that's-
okay.
That was, okay, but this is about burden shifting based on
Yes.
the market share result that would result from the merger.
Correct.
Okay,
Yes.
thank you.
And so then the next option, which Cheryl is alluding to, option 3, gives more concrete guidance. So it does then reference Philadelphia National Bank, but then it states that in subdivision C, a merger shall be presumed to substantially lessen competition if it results in, and then it gives the guidelines, parameters for that standard.
We're going to hand out slide rules to the judges so they can do this calculation?
Sorry?
That's what all the experts are for.
Yeah, okay.
So yeah, just to reiterate what Sarah said, so this one is very more specific in terms of guidelines to the courts. Here is the criteria to create the presumption that's based on the HHI language, et cetera. And then in subdivision D, here, defendant is how you can rebut the presumption. And the standard used is preponderance of the evidence. So that's something to think about as well, what standard there should be. But that's basically, it's just more specific guidance to the courts than option two. But option two is basically Philadelphia National Bank, which is existing law.
And option 3 codifies the merger guideline number 1 that speaks specifically. And then the fourth option sets a new standard altogether. It's a complete departure from federal law, and it uses the appreciable risk standard that was referenced earlier in our memoranda, and is also present in the Senator Klobuchar's Calera bill. So it replaces current federal law with a violation is from a merger that may be to create an appreciable risk of lessening competition more than a de minimis amount. So that is then the new standard for which there is no, it would be new. There is a general understanding that this phrase is meant to reduce the current threshold, which has been argued to be higher than was originally intended, and it would be a break.
So appreciable risk is understood to mean, doesn't have to be very big.
That's the.
I'm sorry, I can't hear you.
Oh,
And everybody, please speak into your mics.
yeah, appreciable risk is presumably a lower standard than 30% or whatever it is we've done in the Philadelphia case.
Well, the problem lies in the court, once again, in the court's interpretation
Right.
of language that was set in the Clayton Act in 1914. That language has not changed at all. It says, it's unlawful to create a merger where the effect may be to substantially,
Yes,
I'm going to butcher this, materially lessen competition or tend to create a monopoly. That language is unchanged, but the courts have required, not all courts, but some of the federal courts have required almost a certainty in the quantity and type of evidence to establish the harm from a merger that hasn't taken place. So it's a very tough standard as interpreted by the courts. So those who advocate for more enforcement of mergers say, well, you've got to lessen the burden on the government to show how this is going to adversely affect competition. Okay. And I think we've talked at one of the past hearings about how, well, appreciable risk, materially lessen, doesn't it kind of sound the same? And that's why I think going to Commissioner Jenkins' point, we use a little different language, but the language has some history and some federal legislative proposals to signal that it is a lower standard and that the government or the challenger to a merger doesn't have to show with certainty the harm of a merger.
So this is not the level of harm. This is the probability of that harm happening.
Yes.
And then the amount of harm in this one that would be necessary would be a de minimis amount.
Right.
Okay.
So those are the 4 options that we presented, and I'm very eager to hear your thoughts.
It's more than a de minimis.
Yeah,
amount.
non-de minimis.
Just to
More than- yeah,
clarify.
right,
it's
right.
like-
More than,
Well,
more than
Tiny bit, tiny bit. Right.
Very small.
very small.
Yeah.
Okay. Okay. So, any,
I guess that if
Those
the
are 4
commissioners have any comments. We could take public comment. What do you
Yeah,
all
any
wanna do?
further?
I just
Yeah,
wanted to ask,
Kara.
is the option not to put language in? Would there be a risk that because we're trying to move away from the federal law that, I mean, because it sounds like if we don't use one of these options, we would just default back to the federal standard?
Well, I think the option would be then you either don't want a California law at all, or you would want a
You
California
have
law
to,
that
you need
mirrors
to
the
do this
federal
portion.
standard.
Okay. Thank you.
Okay, I was wondering, this doesn't speak to, what mergers are subject to state scrutiny at all, does it? I mean,
Are you referring to the fourth option?
no, well, any of these. I mean, I'm presuming like, if we're trying to set up something that is sort of the state version of the federal law, if a merger is over a certain dollar amount, I think you have to notify the feds and they review it and make a decision as to whether it's going to be anti-competitive. I don't see that in here.
So that's a slightly different subject. So that's the SB 25 is the merger notification. So this would be similar to existing federal law, and it does not require notification of a merger. I think it sets a standard for
Okay,
to
so
the extent that somebody finds out
this
about it.
this wouldn't change who has to have a merger subject to approval.
It's not an approval standard. It sets a standard by which the enforcer can say this merger can't happen because bad things will happen to competition.
Right.
And under federal law, it's also not an approval standard.
Right, okay.
The federal government gets notice of certain large transactions and they review them. And if at the end of a prescribed period of time, they don't bring a challenge,
It
the
goes forward.
merger by law can go ahead.
Okay.
But most mergers aren't subject to the HSR notification rules. So, and the states have jurisdiction over their corporations within their boundaries.
Right. And so I'm just trying to, so this wouldn't change if there's going to be a merger to take place. How do the merging companies know they need to notify somebody that they're going to be merging?
Only if state law or federal law requires notice. So for instance, as Sarah mentioned, we have laws in the healthcare area and for pharmacies and retail mergers. Mergers of certain sizes are required to give notice to the AG.
Right.
The AG can bring a merger challenge under federal law right now.
Right.
Of course, they have to go to the federal courts and rely on federal law.
Right.
So this would allow the state enforcers to bring an action in the state court under their own law. If they don't have their own law, they can't bring anything in state
Okay,
court.
no, I got that.
They're
got that.
tied to federal court.
But the only ones that they're going to be bringing actions are ones that have pursuant to federal law required notification.
No, not
Yeah,
necessarily.
No. Oftentimes you get notice of a merger because you read about it in the paper. I mean, it's nothing about notification. And then you say, well, that doesn't sound right. Or, we believe that these parties are already dominant in this area. This is going to create a problem here. Maybe we should take a look at it.
So we're not proposing to change that aspect of antitrust law whatsoever. So we're just changing this, we're looking to import a standard that is currently only existing at the federal level to the California level.
So this would mean that if the AG learns about a merger, either because of federal notification that we're going to get the notification, under SB 25, or they learn about it through some other source, AG would then have the authority to file an action.
In state court. Under state law.
And then depending on which version of this, the burden would either be upon the AG, or the burden could shift if it's going to be under one of these criteria large enough to cause some anti-competitive outcome. The burden would shift to the defendant.
Correct. So burden shifting is currently, is current law. Want some of the options make it a little bit tippier on one end. Is that fair to say?
Well, Philadelphia National sets up a presumption, but many of the federal courts have ignored it in practice. It's an unfortunate area of law where cases are on the books and some courts
Right.
ignore them and some don't.
So currently the argument is that federal law sets a presumption that up to say 70 or 80%, and then you have to prove. This would bring it back down to 30. Is that, or 50 or 60?
Well, the government has some presumptions laid out in the merger guidelines, but there's no other presumptions.
So current law requires a much higher standard of proof, and we're trying to reduce that. Is that fair?
Merger law, I'm sorry.
Yeah, I'm sorry,
Okay.
say again.
So currently, the argument is that federal law requires a very high burden of proof in order to stop a merger.
What's the burden of proof? Beyond a reasonable doubt?
No, you have to show that the effect of the merger, which hasn't occurred, may be to substantially, oh, help me out here.
Sure.
To
Maybe-
Materially lessen competition or tend to create a monopoly. And that standard sounds like you can just raise some possibilities, but that's not how it's been interpreted.
Okay.
And then the defendant comes back and says, well, there may be that possibility of harm, but it's negated by the efficiencies of the benefits, or, you know, or you're just off in terms of your projection of the harm from the merger.
Okay, I'm sorry, Victor?
Yeah, I have a question. The comment that the staff is not making recommendations due to the pendingness of SB 25. Does that have any bearing on us? Should we be holding back? And
No, that's a separate subject altogether.
okay,
And it's consistent with our statutes when there's something going through the legislative process that isn't a space that the commission goes into, even if they're
okay. So
have
we
existing.
can't choose one of these options and not worry about.
No,
the
they,
pendency of it.
yeah,
Absolutely, absolutely. So originally, in reviewing the tapes, the commission voted to both take action on a merger notification law and a merger California standard. And so we're addressing that we're not making proposals as to a notification standard because that exists in SB 25.
My second question is, am I correct that California has not used these HHI index before?
I believe the Attorney General may.
No,
Yeah,
no,
it's just federal guidance. So if they're,
I think HHIs are used in most murder cases. It's just a very common measurement of the concentration and the increase in concentration.
Okay, so it's not something fearful or untested or,
Oh, no. It's very commonly used.
Okay.
It's, in fact, nobody knows what HHI really stands for. They're the Herfindahl, Hirschman, but we just call them HHIs and everybody knows what that is. It's Commissioner Simpson's measurement tape.
I understand there are multiple ways of doing it, but HHI is the most common and understood throughout the antitrust world.
okay.
Commissioner B has a question?
Oh, yeah, okay. Maria.
Oh, sorry, I raised my hand a few minutes ago. My question is, if we adopted option one, which is basically just federal law, the Clayton Act, and made clear that federal law was not binding, would that make us feel like, California had a good law in place? Would that be enough to cover the situations that we're concerned about? Or do we need to be, in your view, more explicit about the burden shifting?
Can I ask a clarifying question before you answer? So as I understand option one, it's to adopt the original meaning of the Clayton Act, not its current interpretation and application in federal courts.
The intention of the first option is to adopt the Clayton Act verbiage, which can be enhanced by any of your directive language to not use federal law. But the second option is intended to adopt sort of the Philadelphia Bank points of interpretation for the Clayton Act.
Which is the burden shifting issue.
Yeah.
Right. But so, I mean, as I understand Commissioner B's question, it's really getting to what does option one actually do? And if it both adopts the Clayton Act and its original interpretation before the modern Chicago school did what it did, then I think it does accomplish something substantial. If it doesn't, then it just adopts federal law as it exists right now, period.
This is the option that creates the least uncertainty. So this, on the scale of options, this was the most conservative option. It does bring into California law a merger standard.
Okay. So what's the answer to Commissioner B's question?
I think that's up to the commission. It's kind of a value judgment. I personally don't think it really does a whole lot. I mean, it's certainly helpful. I don't practice in this area. I have heard that any change would be good. But the other options would create greater certainty for changing federal practices.
I think it doesn't address the concerns about presumptions and how that's been weak at the federal level.
And the high level of proof.
I think the advantage of having a state court regime that mimics federal law at least allows you access to your state courts. And that's important. It's important for the state to have that option to go to their state courts. We have a very different way of picking our judiciary. And as our mergers and acquisitions group working reports said, if you just go to state court judges, you could very well have a different reading of the Clayton Act because of the different processes that select judges.
And this is also intended to go in the Cartwright Act. So any of the language that the commission was considering from the findings and declarations or codified direction would also apply.
So D&E would apply to this. Commissioner B, I apologize for hijacking your question. Did you get your answer?
Yeah, and that was helpful clarification.
So in option one, the burden of proof is on the AG to demonstrate that it may substantially lessen competition or tend to create a monopoly or monopsony in any line of commerce or an activity affecting commerce in any section of the state.
Yes.
Okay. Is that a preponderance of the evidence standard?
Yes.
Okay.
And then the defendant would have an opportunity to say, yes, but we're doing these other pro-competitive benefits.
Where they would be able to rebut, but when you look at a Philadelphia national presumption, instead of the government having to prove that the merger is anti-competitive and will have a negative impact on competition, the defendant has to prove that it won't have an impact, a negative impact.
In Philadelphia, okay.
Yes.
The state doesn't have to prove that it will.
emerging parties have to defend that it
Well-
won't have a negative effect.
If it's over a certain threshold.
Right.
David?
On page 5, there's a statement at the very end of the discussion about option 1 that there are reasonable arguments for changing the Clayton Act's problematic standard to clearly reset judicial interpretation. What are those reasonable arguments?
People think it's too hard to block a merger these days. There is particularly a letter from one of the Professor Newman, who was arguing that while the Clayton Act language has been unchanged, the courts have required higher and higher proof of harm to where, as Cheryl was mentioning, the risk of harm is required to be proven to an almost certain amount, which has been very difficult. So there have been fewer mergers that have been able to, that are being prevented.
And I think in the memo, that's sort of the transition sentence, but if you go through the following, the other options, we always have something that says this is the benefit of doing it this way. This is the potential drawback of doing it this way. So I think those, that analysis addresses that, but we're certainly willing always to do more.
No, I just wanted somebody to unpack for me the core concept of.
And so the way the options were presented was that because that threshold is so high, the first option is current law, which arguably doesn't change that at all. The second option resets that standard to where people think it was better in 1963 with this particular case. The third option built on that standard, but is much more prescriptive based on current federal guidelines. And then the fourth option changes it considerably, or arguably replaces it back to where they believe Philadelphia National Bank or that area was decided. So that's the progression of the options.
And Philadelphia National Bank is still the law of the land, but some courts ignore it. Okay. Other questions or comments from commissioners?
I have one more question.
Yeah.
Sarah, do you think that there's any risk of using the federal merger guidelines that we're skewing closer to federal law and the idea that, federal law might apply? Or I'm just wondering, if we're trying to make clear that federal law is not binding in this new California law, is there any issue with using these federal merger guidelines?
Yes and no, but mostly no. I think in this particular argument that we're saying that some federal law is good, like, for example, Philadelphia National Bank. And in referring to the federal guidelines, this is an established set of guidelines that were agreed to by a large swath of individuals, and is current law. And it's very, it's a roadmap for enforcers, and everyone knows where the lines are drawn. The federal law does change, and because we're specifically referencing the 2023 federal guidelines, if indeed it does change, and it has changed, I think this is the third or fourth version, we're saying we still like this one, and this is believed to be an interpretation of existing law. So we are currently picking and choosing what of federal law we would like.
Okay, that was my next question. What if it changes? But you answered that. Thank you.
Okay, thank you.
Get to public comment.
Public comment? Is there anybody online that's indicated, not
Oh.
yet? All right.
So it's already 4:20. So if you could keep it brief, with the understanding that there's going to be more opportunity to comment on this, we would appreciate it. Thank you.
Yes. Just two thoughts. One is a lot has happened since 1963. As somebody who cited to you a unanimous 1960s Supreme Court case, I'm glad to see that, we're looking back there again. But as Cheryl mentioned, in 1963, when the government brought a case, she's right. The other side had all the information. The government didn't have it. So maybe there was a need for a presumption. But in 1976, the federal government passed the Hart-Scott-Rodino Antitrust Improvements Act that required parties to give a lot of information to the federal government for mergers. Now it's over $125 million, and HSR has been changed. And so there's a ton of information that's required to be given to the federal government. Of course, I'm working to make sure that our state AG gets it too. But so for example, if you make a presentation to the company's board of directors, the ultimate authority of any company, where you have an obligation to tell them everything with candor about what the merger is going to do or not going to do, that presentation has to go to the government. So there's a ton of information that the parties didn't have in 1963. Things have changed and things have improved. And then just another point, it's, we talk about mergers, but it's mergers and acquisitions. And acquisitions covers lots of assets. So, if I want to buy some copyrighted book and turn that into a movie, that's covered. And so you have to think about that too. Like, do we want the state AG to make decisions about what movies get made or things like that? This was a big issue in the earlier version of the New York bill that has failed 5 times. The good news is Senator Gianaris has taken the ULC product and put that in instead of his wayward ideas in M&A. But it's just something to think about. It's not just about, Kroger, Albertsons, big company A and B, but there's a lot of little acquisitions that are also covered by this that need to be part of the thought process. And I've only read the paper once, and so I'll think more about it and try to give you some other thoughts. Thank you.
Eric?
Very briefly, we haven't had a chance yet to fully digest the paper. It's well-written, and we're going to spend our time looking at it, and we'll give a written public comment. Thank you.
Thank you.
Okay, unless any of the commissioners want to discuss this we have 2 people online. Okay, we have 2 folks online that joined us, so.
Okay, Jennifer Suh.
Hi, my name is Jennifer Suh, and I'm speaking on behalf of the Writers Guild of America West, a labor union that represents thousands of writers of movies, television, and streaming series in California's vital media and entertainment industry. We commend the Commission staff on their work regarding this ongoing study. Our members experience the harms of unchecked consolidation, deregulation, and antitrust under-enforcement firsthand. We've opposed harmful mergers and acquisitions in our industry for years, including opposing Amazon's acquisition of MGM and the Disney 20th Century Fox merger. And we documented harms to diversity in the wake of the Warner Brothers Discovery merger. We're pleased to address the Commission again today to express our general support for the staff's recommendations to update California law to regulate mergers, and to urge the Commission to move forward with adopting and submitting a recommendation to the legislature. Whichever final language the Commission adopts, we strongly believe it must allow for robust merger review and enforcement in California, independent of federal agencies and the shortcomings of federal law. As we articulated a year ago before the Commission, decades of mergers and acquisitions have transformed our industry into one dominated by just a handful of companies, including Amazon, Netflix, and Disney, who abuse their position of dominance with workers, consumers, and competitors, and threaten to consolidate even further. In just the last 7 months, both Comcast, NBC Universal, and Warner Brothers Discovery have announced plans to spin off their linear networks from their streaming businesses to better position them to pursue M&A transactions, as Wall Street continues to demand more consolidation in our industry. So without government action, consolidation will continue to go unchecked. In this moment especially, Californians can't depend on the federal antitrust enforcers to block future transactions that harm workers and consumers. With these staff recommendations to the legislature, the Commission has the opportunity to introduce a broadly applicable California merger statute for the first time. Staff's recommended options 2 and 3 in particular build on federal law and codify parts of the DOJ's and FTC's 2023 merger guidelines. We supported the adoption of these guidelines in 2023 and are pleased to see them utilized here. As we articulated in our previous comments to the Commission, we'd like to see lower hurdles to prove that proposed transactions are anti-competitive in labor markets, such as greater deference to direct evidence of market power. Numerous unique characteristics of a labor market for members mean that a pure market share or HHI assessment understates the reality of employers' market power. And as the 2023 merger guidelines correctly noted, mergers themselves can lower demand for workers, further complicating the use of market share alone to assess levels of competition and likely harms from the loss of that competition. We look forward to engaging on the proposed options and will continue to provide feedback to this Commission. And we thank you for the opportunity to comment and for your work on this important subject.
Thank you, Jennifer. Are there any questions or comments for her? Hearing none, seeing none, thank you.
Benjamin O'Brien.
Thanks. Sorry, I had to relocate, but appreciate the time to speak again. I'm just going to echo Eric's comments and that CLS is reviewing the merger and then the misuse of power stuff. So we will respond with written comments and then we'll be at the meeting coming up in September. But thank you.
Oh, okay. Thank you.
Or
That it? Okay. Anything more that the Commission wants to discuss or ask on mergers and acquisitions? Hearing none. We want to start
sure, I could do,
misuse of power?
yeah, Sarah and I can do misuse of market power really quickly. And I'm sure everybody's pretty tired at this point because it's very complex, detailed analysis that we've been going through. So basically what this memo is a status update. We have some draft language because we were hoping the commissioners could start getting their brains wrapped around it and think about it, but we wanted to put them out, but we think they need more work. And what we're hoping to do is work with Cheryl and other experts on how we can fine tune the language. And perhaps the goal would be that we can have a memo published for the next meeting well in advance of the meeting. So, and then reach out to all the public commenters and say, hey, do you want us to give us some more feedback so we can bring that to the Commission at the September meeting? So, like the memo we just did, we're not requesting a decision. And I already said that the Commission should consider the draft language preliminary. We're continuing to analyze the concepts and other language options at the recommendation of our antitrust experts. Would you like Sarah to give a sort of a high level overview?
Yeah, that'd be helpful, particularly to distinguish between the two.
Sure.
Sure. And thank you, Commissioners. This is indeed preliminary because it's a very difficult concept. I think generally speaking, the idea of abuse of dominance, misuse of market power came in reaction to federal law. And I think if the way I've been thinking about it is if you reset California law, this may not be as important as it was at the federal level. Having said that, the first option ties to whatever standards the Commission is looking to set for both single firm conduct and mergers. And it sets presumptions for companies for certain activity. So it basically says the government prosecutor can demonstrate substantial market power by direct or indirect evidence, and we picked 30% and $500 billion. And then we said, if you're over those two, then these things are presumed illegal unless you can rebut the presumption with by a preponderance of the evidence that the pro-competitive benefits outweigh the anti-competitive harm. The second
Wait, so it says, basically, if you have substantial market power, which is 30% or a certain amount of assets, then if you do any of the stuff in subdivision A, that's illegal.
unless you can prove that it's not. I mean, unless you can prove that the pro-competitive benefits outweigh the negative
Of
benefits
that conduct.
of the conduct, correct.
Okay.
And those behaviors we put lots of footnotes in there. Those seem to be fairly widely accepted behaviors that become problematic when done by individuals with substantial market power. And
So again, with this option, we did look to federal law and state law, and again, reminding the commission that ACR 95, the resolution that directed the commission to conduct this study, wanted the commission to consider those issues. So, at this point, I think, and Sarah, correct me if I'm wrong, but I think we're drawing on things that are out there, but thus far have not been successful.
correct. And so what we're hoping for guidance from you, the major thresholds for this type of legislation, and again, in the United States, none of this has passed yet. We look particularly to CALERA, the New York 21st Century Bill, and then there's a Minnesota bill out there as well. The thresholds are important. So whether you want to require a certain percentage or a market share, and the standard by which those behaviors are judged. So in the first option, I tied it back to whatever the commission chooses for the single firm or the merger conduct. And in the second option, there is no list of conduct, but a bad behavior can be judged against that the conduct is likely to harm competition in more than a de minimis way. So while there is a list of conduct, that conduct is not presumptively unlawful. It has to be judged against this new standard.
Tell me again how in the first option, they engage in that conduct. It is per se unlawful.
Is not per se would be it's automatically illegal. This sets a presumption that can be rebutted by evidence.
It's
that
presumed,
says that
it's presumed to be, a person with the substantial market power is presumed to violate it if they do any of this stuff.
correct.
Okay.
But then they can say, hey, but it really did work out better for everybody.
All right.
And so that
And
they
in
can-
option 2, the list of stuff is how does that differ?
Sure. It's a non-exhaustive list, so
Right.
it can be
There's more,
more,
there could be more.
could be
There other
more.
things.
And that behavior is judged against is likely to harm competition in more than a de minimis way standard, which the words were chosen for the principle that harming competition is the point of antitrust law, and de minimis has been echoed in various pieces of legislation, and it appears in the California codes. I think there's about dozens of times. And it's meant to be a lower threshold.
Okay, questions or observations or anything from commissioners? So this is something for us and for all the audience at home to look at and think about. Oh, I'm sorry, Maria.
I have a question. Sarah, if California adopts the broad single conduct standard, do we need to have a separate misuse of market power provision, or would that broad and flexible provision that we adopt cover any conduct that we would want to punish under these sections?
Glad you asked that. Some may argue you still need it, but I believe that if you adopted a broad enough standard, then it certainly would cover this behavior.
Okay, thank you.
And the, in an action brought under the single firm law, they would look at whatever the actionable conduct is and look at, is that going to be anti-competitive in the context of the market share or all that sort of stuff, right?
This is meant, the structure is meant to sort of shortcut some of the initial proof the requirements to bring the case where you say, oh, you're a very big company or you have this and it looks like you did this. All right, we're off to the races. So there's probably more development required in using the single firm conduct law, but essentially they cover both behaviors.
That helps.
It strikes me that the problem with this misuse of market power is that, rightly or wrongly, people are going to claim this is abuse of dominance. They're just going to say it.
Yeah.
And that seems to be a certain rallying cry that you can't be European. God knows the Europeans don't believe in capitalism. They're just democratic socialists and so forth. So if we can avoid the issue of misuse of market power by having a robust single firm rule and just not have to pass anything like this, again, it goes not substantially necessarily make a difference, but goes to the whole concept of trying to get this through the legislature and it being able to pass more readily before people start screaming, oh, look, they're changing the misuse of market power. They're adopting European standards.
Arguably, if whatever California chooses is a reset at any level from federal law, this sort of structure becomes less necessary.
So as a matter of prudence, it might be worthwhile to just avoid this issue if we have a robust enough single firm conduct rule.
It's for the commission to decide, but that is a possibility.
Well, I think it's fair to say with the single firm conduct options, we don't really have presumptions. And changing the burden is fairly critical in antitrust cases because people are allowed to argue basically anything. And the rule of reason allows the court to examine all the different factors. And these factors aren't of equal weight. And the court's like trying to weigh all of these. And the winner is going to be the person who doesn't have the burden of proof. So these cases are also very resource intensive and incredibly expensive because the parties are allowed to argue about anything. They can allow this is a benefit, or we're going to do this, or we're going to do that. And so by having presumptions with particularly large dominant firms, because it's their conduct, it's the conduct of a handful of firms that can leverage their dominance in ways that preclude others from entering the market, that I think enforcers are particularly concerned with. And that's kind of what prompted ACR 95. We're looking at dominant firms that are spurring all these legislative proposals. So this misuse of market power really addresses that. It talks about some of the unique harms that come from large dominant firms that also provide services to people they compete with, and restrictions on inoperability, data portability, discriminatory access, and then kind of special unique things that only a handful of companies can do. And it's very hard to kind of fit them in a very broad law that says you shall not unreasonably restrain trade or monopolize. And the courts often, in looking at monopolizing, say it has to be 50%, 60%, 70%, 80% of the market. But we're finding that dominance can come at a much lower rate.
Rick?
But it strikes me at 30% seems low to me. No? Okay.
It depends on the industry.
Sure.
Very much so. The pharmacies, we have 3 PBMs that control about 80% of all the prescriptions in California. So those 3 each have, a third of the market. But if you're a little independent pharmacist, can you do without a third of your customers?
So you're recommending we do address the misuse of market power and actually make an option?
I certainly think it's something that ACR 95 tasked us to look at. And, it's.
So that's why we're exploring it, whether to actually adopt something is going to be up to the commission. And sort of the one thing we wanted to do is, because the last time we talked about this, there seemed to be a lot of skepticism about potentially artificial thresholds and, how do you measure these things and how is it done? And so we were hoping to get, a little bit of a read of what the appetite is. And we're certainly happy to continue to work on it. And, as I said, and as Cheryl said, that ACR 95 contemplated that at least that's something that the commission is going to look at. They weren't telling us you have to make a recommendation on it. But so that's why we're having the discussion today. We wanted you to at least start thinking about it. If there's any strong feeling right now, let us know.
I don't mind the discussion and the continuing exploration, but at the end of the day, I don't have a problem with not opining on misuse of market power. And as a baby step sort of idea, just going with the single firm conduct passage, getting something that will actually get through. And if it turns out to be a problem, that this unreasonable restraint of trade concept can't capture what we're trying to deal with, the legislature can write something else on addressing misuse of market power. But I'd like to get something passed rather than to have the whole construction fail if we put too much on it.
David.
It seems like there's 2 pieces in this concept. One of them is burden shifting, and the other one is the presumptions. What you have to show when you have the burden of proof or when you're defending. I think the first part of that is something that can be dealt with potentially in single firm conduct. We could incorporate a burden shifting structure within that. That would address the first part. And on the second part, my thoughts are in 2 pieces. One is that if a company truly has 70% market share, I think that will tend to, as a practical matter, make it much easier to show that whatever act they're accused of doing that's anti-competitive, it'll be easier to show that that is an unreasonable restraint of trade as a single firm conduct act because of their outsized market share and influence. I think just as a matter of proof, that'll be easier to show that whatever pricing controls or tying or whatever they're doing, that will be easier to prove just as a practical matter. And I think that trying to approach that from the numerical presumptions angle, as this memo suggests we could do, I don't see any way that we get away from the arbitrary number problem. At best, we're going to have a battle of the experts where Cal Chamber and the MPA and everybody else is going to run in here with a stack of PhDs and try to convince us that one number is better than another. And I seriously doubt we're ever going to be able to figure that out. And I pity the poor judge who has to figure that out. And I wouldn't want to stick anybody with that job. I don't want us to have to figure that out. I have no confidence we'd do a good job with that. I don't want to make any judge have to try to figure that out. I just don't see how we get past the arbitrary number problem if we're going to do presumptions. And so to me, it all cycles back to, I think we can achieve a lot of the purpose here with single firm conduct, and that avoids the arbitrary bright line rule problem. So
And maybe,
I would not do this. I would solve as much of this as we could with single firm
maybe
conduct.
with the burden shifting.
Yeah, yeah. Yeah, I still think this is a bad idea.
Yeah, I mean, somebody who can undertake one of the actions on the list here that's only got 29% of the market, if they get another percentage of the market, then there's a
Yeah, and you can get perverse results like, okay, so out of 100% of the market, there's one company that has 70% and there's two companies that have 15% each. If those two companies merge, they have a combined 30% of the market. That hits this threshold, even though there's a behemoth on the other side of the ledger that has more than double their market share. That would just be insane.
There's a tension between selecting arbitrary market shares and not having any metrics that control when the burden gets shifted. Because again, these cases are so resource intensive. They take years.
Yeah.
And
that
millions
in
of
itself is an
dollars.
argument against doing this.
That's why some people say that we have very low enforcement against anti-competitive conduct and increasing consolidation because it's just too hard to bring an action and succeed.
So,
Okay, we didn't do public comment on this yet.
we have to do public comment
Yeah,
on
yeah,
everything, and we haven't had it yet. So, but just in keeping our eye on the prize, if the commissioners could kind of think about, I've heard Commissioner Carrillo's idea of like, well, why don't you look at how you could incorporate this into single firm conduct? And
At least the
so
burden shifting part of it.
do you want us to keep like working on this approach, or would you rather have an alternative approach? So anyway, but let's do public comment. Sorry, I couldn't help myself.
And is there anybody online that we're waiting for? One? Okay. Dan?
Bear in mind also, there's tremendous rewards for pursuing these actions. This is one of the only fields I know where you get automatic treble damages, costs, and all of, Eric's, he's gone now, but all of his attorney's fees, to the, prevailing plaintiff. It's pretty significant. I don't have a strong view on this topic, but if we're going to start by saying, okay, 30%, I've got a presumption that you're guilty, and I'm moving along to capture all those monetary rewards. There's plenty of that goes on, and just keep that in mind. And also, I would just say, the people who come here, try to give you constructive criticism. I think, as I've learned the hard way with SB 25, the people who are sharpening the knives, who don't show up, but then come to get you, those are the ones you should be worried about. Anyhow, just two random thoughts on that.
Thank you. And our other person?
Bryn O'Neill.
Okay.
Hi. Thank you.
Hi. Welcome.
Thank you. Thank you, Chair and Commissioners. I'm Bryn O'Neill, Regulatory Policy Specialist with the California Nurses Association, a labor union representing over 100,000 registered nurses across California. We first want to again thank the staff for all their work on the antitrust study. CNA wants to briefly comment on the new memos in this study on misuse of market power and on mergers. With the growth of corporate consolidation, particularly in healthcare, we need California to update our antitrust laws to provide meaningful tools to address the negative impacts of concentrated markets on the lives and well-being of workers, patients, and everyday consumers. Specifically, on the misuse of market power memo, both options would be an improvement over current law. That said, we prefer a combination of option 1 and option 2, where there's a non-exclusive list of conducts that are presumed to be a misuse of market power. While we prefer option 2's non-exclusive list of conduct that could be a misuse of market power, the legal presumption in option 1 would help ensure that workers and consumers are not saddled with the evidentiary burden of proving the harmful purpose or effect of the potentially unlawful conduct. Additionally, as CNA, Economic Security California, and other organizations wrote in our antitrust report submitted to the Commission, there are several other types of conduct that could be included as examples of misuse of market power. For example, the abuse of labor market positions to union bust or force workers into anti-competitive contracts that restrain workers' labor rights or labor mobility. Finally, on the merger memo, CNA would like to reiterate the importance of expressly codifying current antitrust case law, which recognizes labor market theories of harm and harm to workers in any merger review standards. Thank you again for all your work on this important study.
Thank you. Any comments or questions for Ms. O'Neill? Seeing none, thank you.
But
Sharon?
I guess we're looking for direction on where to go next with this. I don't know if Cheryl had any.
Well, I think I would guess look into Commissioner Carrillo's thought about maybe moving the burden, some burden shifting into the single firm.
Yeah, if that's feasible. I'd like to see if that writes,
Yeah. If there's some way
if that's
to
feasible.
do that. I'm not sure. We have to think about, about what would trigger the shift of burden.
Mhm.
Yeah.
Likewise, I think you could split out what certain mergers of a certain size
Right.
and shift the burden.
Right.
So to split it into single firm conduct and merger.
Yeah, but I wouldn't do it in terms of like market, like, because again, I want to get away from arbitrary rules, but you could do something like if, and based on number of participants in the market, again, you still have a problem of defining participant in market, but if there's only 2 companies in the country that do pagers and those 2 companies want to merge, okay, well then that's pretty simple.
And there's some thought that you have mergers, a presumption which would shift the burden or show that the merger isn't going to be harmful where there are huge companies,
Yeah.
companies with over 500 billion in market cap.
Yeah.
There's 18 of those companies,
Yeah.
and they tend to do a lot of mergers that don't even reach the HSR level. So I think between Meta, Amazon, Apple, forget the other 2, they did 819 mergers over a 3-year period of time, none of which were approved by the federal agencies, all of which escaped any scrutiny. And a lot of the consolidation has taken place by acquisitions.
Huh.
Any other thoughts or guidance for staff? Where do we go?
Move to adjourn?
Or is
I
there,
move we adjourn.
it's been moved to adjourn? I'll second that. Any objection to unanimous,
we have to,
any
yeah.
unanimous roll call? Hearing none. We are adjourned. Thank you all.
Thank you so much.